While she was underground, Assata Shakur became involved in the fateful incident on the New Jersey Turnpike, resulting in the killing of New Jersey State Trooper Werner Foster. Assata Shakur left New York with two men, Messrs. Clark Squire, who would be wounded in the shootout, and Zaid Shakur, also known as James Costin, who would be killed in that shootout. They all headed south on the New Jersey Turnpike.
We stopped to eat. We at a Howard Johnson's restaurant. We ate. We got back into the car, and shortly after, we were stopped by the police, by the New Jersey State Police.
There must have been some dialogue between the three of you in the car, because you were, for lack of a better word, on the lam.
Between the three of us? Well, yeah.
So you must have said something, you know.
Well, actually, I mean, we were stopped, but we did not think that there was, you know, we thought it was maybe some little thing, and that Sundiata was going to go back and show him some ID, and that it was a question of maybe we didn't really know. So Sundiata decided to go out and present the ID so that, you know, we can go on peacefully. And that was basically what was in our heads, although that, I mean, there were all the other considerations that registered in the back, but I don't think that we really were alerted that, you know, this is a situation where they're going to start shooting in the car. I mean, I was not thinking that, really. I said, well, this is, you know, I was nervous. I was like, okay, you know, but I didn't think that it was going to be all that.
Can you tell me what he said to you as best you can recall?
I can't.
Was it something, did he call you by name? Did he talk about, you weren't driving?
No. The driver had gotten out of the car. He came to the car and started to question me, and where were we going, what, you know, that kind of stuff. And then he said, put your hands, you know, in front of you where I can see them. And
which would have been the dashboard, I guess, inside the car.
No, I was facing him. You know, he had a gun in my face, and I put my hands out like this. And in a matter of seconds, I was shot. I mean, it was like a nightmare. It was like, you know, it's like in a dream. And it didn't seem real, but it happened.
There are many, however, who disagree with Ms. Shakur's account. Among them, the jury who heard the case against her and found her and Charles Squire, her surviving companion in the car, guilty of murder. The superintendent of New Jersey State Police also differs with Ms. Shakur. He agreed to be interviewed, where the prosecutor of the case, the presiding judge, the FBI, and the U.S. State Department did not.
Our troopers were on patrol. Werner Foster and Jim Harper. They saw an automobile, and I may be wrong on some of my details because it's been some time.
Yeah.
But the inspection sticker on that automobile did not match the license plate. They saw the sticker, they recognized it. They knew that the origin of the car was not the same as the origin of the license plate. They stopped the car. As they were questioning them, there were three people in the car: Joanne Chesimard, Clark Squire, and James Costin. A gun battle ensued. We charged Joanne with shooting and causing the death, being part of the group to cause the death of Trooper Werner Foster, who was murdered at the scene. James Costin was killed at the scene. Clark Squire escaped. We caught him locally about 3.5 days later. Joanne Chesimard was shot in the car. Trooper Harper was wounded. There was a violent exchange.
I was shot once under my arm and once from the back.
The bullet under your arm, where did the bullet come out?
It didn't. The bullet is still there.
It's still in you?
Mm-hmm. It went through here. It broke this bone, and it's still in my chest. I was, this hand was paralyzed.
Harper stopped the car. Foster came up behind. But Werner was completely removed from this kind of mix that would give rise to the argument that this was a racial confrontation. It wasn't a racial confrontation. Joanne Chesimard was one of the most sought-after fugitives in this nation. Every policeman in New York or Los Angeles was, in one way or another, looking for Joanne Chesimard. And now I'm convinced they were doing their job and doing their job properly.
The first week was the most difficult week. I mean, if you can imagine what what they did when they found out who I was. They wanted information. They thought I had it. And they did everything that they could to get it out of me. They didn't just beat me any old kind of way. I mean, they had a constraint. That was probably what saved my life. And it was what was taking place was in a hospital. They took me to a suite of a hospital. It was the Johnson & Johnson suite. It's where executives go. And in order to get into the hospital room, you had to go into a living room, which was attached next door, so they controlled who came in, who didn't. And I was accused of killing a state trooper, and state troopers for 2 weeks guarded me, quote unquote. And you can imagine, they did everything they could. Every day was going to be my last day on earth. When they get next to the bed, and they cuffed me to the bed, and the cuffs were sticking in my legs until, they started to swell. Where does it hurt? Does it hurt here? Does it hurt here? I mean, that was part of what happened.
Jill, let me tell you something.
Yeah.
I've been working with offenders for 35 years, and I can't think of an offender who would have been better guarded, or an offender against whom we would have guarded against any kind of improper activity than Joanne Chesimard. I think that it would have been foolhardy for anyone to have done things like that. I'm certain that the troopers who guarded her were not in love with her, but I'm also certain that those troopers were clear in their minds that if they didn't watch what they were doing, someone was going to take her away from them. And I've listened to all the reasoning. I've listened to all the accusations. I don't believe them, to be very candid.
I opened my eyes and I was trying to adjust to the light, and I kept looking at something that was next to me, and I realized what it was. I was looking at a plastic bag, and that inside that plastic bag was they. And then I heard a voice say, if you don't tell us what we want to know, this is what's going to happen to you.
Assata Shakur was tried and convicted of murder by an all-white jury. She was issued a mandatory life sentence. Clark Squire, who was also in the car with Ms. Shakur, had been similarly convicted and sentenced in an earlier trial.
I was convicted of killing a New Jersey state trooper, which is a state offense. They transferred me under an agreement called the Interstate Compact Agreement, which says they can take any prisoner in the U.S. and transfer them anywhere they want to. So they transferred me to a prison in Alderson, West Virginia, which is the federal prison for women, to a prison within a prison, the maximum security unit or something I was called. In that prison, I found that it was the exact opposite of all the experiences that I had seen in prison. In my whole time in prison, most of the women are black or Puerto Rican. The only black woman in the maximum security prison at Alderson, West Virginia. In a prison with the Aryan Sisterhood, about 11 or 12 members, people who wore swastikas on their jeans, who took pictures in giving the Hitler salute. I was in prison with them and with the Manson family. Women they call themselves red and blue. One was Squeaky Foam, and the other one was Sandra Good. And the Aryan Sisterhood, a few hillbillies, the Manson family, and one other woman who, Rita Brown, who was not she was a revolutionary woman, but white. That was where I was put.
Who threatened you against you?
Of course.
She wasn't being set up. She was setting up. She wanted to come back to a Jersey jail that she could get out of. That's what she wanted to do. And she did it very skillfully.
Is it true, what she claims, that she was incarcerated with the woman who shot Gerald Ford,
That's
the
correct.
Manson women, and some female white Nazis or something
I'm
like
not sure about the others, but she certainly was incarcerated with, was it Streaky Frome? Some name such as that, who tried to assassinate President Ford. But it doesn't make any difference, does it? She was incarcerated with all kinds of murderers when she once got to Clinton Farms here in New Jersey.
Fortunately, this unit was closed down. Not because of any kindness on the part of the Federal Bureau, but these women were all white women. So that their considerations were taken into account, and they decided that unit would be closed. I was then sent, first I was put in the hole for a while until they figured out what they were going to do with me, and after that they sent me to New Jersey, to Clinton Prison for Women.
It is my heartfelt belief that all the people on this earth deserve justice. Social justice, political justice, and economic justice. I believe it is the only way we will ever achieve peace and prosperity on this earth. My name is Assata Shakur, and I was born and raised in the United States. I am a descendant of Africans who were kidnapped and brought to the Americas as slaves. I spent my early childhood in the racist segregated South. I later moved to the northern part of the country, where I realized that black people were equally victimized by racism and oppression. I grew up and became a political activist, participating in student struggles, the anti-war movement, and most of all, in the movement for the liberation of African Americans in the United States. I later joined the Black Panther Party, an organization that was targeted by the COINTELPRO program, a program that was set up by the Federal Bureau of Investigation to eliminate all political opposition to the U.S. government's policies, to destroy the black liberation movement in the United States, to discredit activists, and to eliminate potential leaders. Under the COINTELPRO program, many political activists were harassed, imprisoned, murdered, or otherwise neutralized. As a result of being targeted by COINTELPRO, I, like many other young people, was faced with the threat of prison, underground, exile, or death.
Katherine Massey Book Club, Context of White Supremacy, the worthless Negro from Virginia. Gus T. Renegade in for another broadcast, hopefully to share constructive information with non-white people, victims of white supremacy. Today's date, Friday, October 31, 2025. So I have been told, nothing spookier than the system of white supremacy. Boo on that. Our fourth installment of Evelyn Williams Inadmissible Evidence, the story of the African American trial lawyer who defended the Black Liberation Army. We are picking up Chapter 10. 10. The audio that we heard in the background, I think many folks, certainly folks who are maybe a little bit older or maybe did their research a tad, a lot of content on YouTube and such. The great Gil Noble had his television program Like It Is many decades ago. He did a whole hour installment on Assata Shakur. Went to Cuba, in fact, to speak with her directly, and included some of the audio snippets from the time, news snippets from the time period to give more context to what happened with her report. But I thought that one was fantastic. Actually didn't see that on YouTube, although it might be on YouTube as well. But she recounts her experience, the shootout on the Jersey Turnpike. Again, last week as we were reading Evelyn Williams, she just goes right to the transcripts from the officers' testimony who were on the scene of the shooting back in '73, and she notes the discrepancies in what was reported by these white officers when they went back and began telling and accusing all these black people of being the greatest cop killers in the history of this part of the world. She said that after this shootout, she was taken to the hospital, and same like last week when we were told it was all the racist enforcement officers who had shotguns and everything. Evelyn Williams talked about that and being strip searched before she could get in to see her. And this week she said that she felt like she was seeing light in a plastic bag, and then they showed her the image of Zaid's body in a plastic bag, like a body bag type of a thing. Like, this is what's gonna happen to you. You're gonna go out. I mean, wow. This is after she has been shot, gravely injured. I mean, is this Guantanamo Bay, Abu Ghraib? Like, what is going on? Total white terrorism. Maybe that was a part of, COINTELPRO as well. Maybe they waterboard you and come up with all their terrorism techniques at the same time as well. She said that they transferred her from New Jersey, and they sent her to prison in West Virginia. Yikes. And she said, importantly, it was the total opposite. They had her up tri-state area, lots of dark people, no surprise there. They moved her down to West Virginia. She is the only black female. Now, we have read a number of prison books before. We read the biography on Geronimo Pratt, same time period. He's going to be mentioned this week. We read Mumia Abu-Jamal, live from death row. Man, we have heard about black people being put in prison situations where we think and hope you will be killed. We aren't going to have to do it directly. We just, even Abraham Bolden that we read earlier this year, we put you in a prison situation where, yeah, it's very easy that you could be killed and it'd just be, whoops, that sort of thing happens behind bars. You should have behaved yourself. They definitely say that with a cop killer. They sent her to West Virginia. I'm the only black female. She said that they had the Aryan sisterhood. Wait. I thought it's the man who practices racism. What you mean, the Aryan sisterhood? And then, importantly, not all white peoples is racist, because we got the revolutionary white sister, Rita Brown. I actually didn't know anything about her, so I had to read her bio a little bit, and apparently she was an actual for real bank robber. They got whole books and what have you on her. Apparently she had some affiliation with George Jackson, Black Panther victim of racism, who we talked about before. But I mean, dang, they always got to find a way to find a John and Jane Brown. We'll have to get a little bit more detail on Rita Brown and see if we think she qualifies as a non-racist bank robbing white woman. That said, I found it fascinating that she mentioned all the people that she was incarcerated with, infamous, some of them, in the Manson family and such. She said she was incarcerated in West Virginia with Lynette Fromme. This white woman tried to assassinate President Ford in 1975. That stuck out to me because I just saw the flippin' movie at the Seattle International Film Festival, Suburban Fury, about Sarah Jane Moore, white woman who also tried to assassinate President Ford in 1975. You got two different white women, racist suspects, who tried to kill the president in the same year? Yes, and they both lived to tell about it. And neither of them had to go to Cuba. We get to it. Katherine Massey Book Club, context of white supremacy. Audio segment 1, Inadmissible Evidence.
Assata Shakur, Havana, Cuba.
Chapter 10. The trial was delayed from September 6 to October 9th while the administrative judge, Leon Jarofsky, decided our two motions. Our motion challenging the jury array charged that the county systematically prevented blacks from being represented in the jury pool in the same proportion they were represented on voter registration lists, 5% black registered voters out of the 583,813 registered voters in the county. In our second motion, we maintained that the massive prejudicial pretrial publicity prevented a fair trial, and we supported our contentions with every newspaper article printed about Black Liberation Army activities since 1971. We would have added documentation of television and radio coverage, but we didn't have the money to pull together that information. Based on all of that, our motion requested a change of venue for the trial. We cited parallel circumstances that had existed in Shepard v. Maxwell, Irvin v. Dowd, and Estes v. Texas, in the latter of which the Supreme Court of the United States had said, "The court has insisted that no one be punished for a crime without a charge fairly made and fairly tried in a public tribunal free of prejudice, passion, excitement, and tyrannical power." Along with these legal procedures is the requirement that the jury's verdict be based on evidence received in open court, not from outside sources. In Irvin v. Dowd, the Supreme Court, setting forth the nature and extent of pretrial publicity that branded the defendant guilty of murder, had concluded that any conviction in a community so pervasively exposed to prejudicial pretrial publicity could be but a hollow victory. And we ended our memorandum with a quote from a New York State Court of Appeals case that insightfully evaluated prospective jurors. I cannot assume that the average juror is so endowed with a sense of detachment, so clear in his introspective perception of his own mental processes, that he may confidently exclude even the unconscious influence of his preconception as to probable guilt engendered by pervasive pretrial publicity. Jarofsky denied both motions, opining in relation to the first that jurors are chosen by computer from registered voter lists and suggesting that if there were fewer blacks on the panel, the reason lay not in the very fair selection process but in the lethargy of the black citizenry who did not bother to register. Having no further recourse, appeal from the ruling could not be made until after conviction, we reluctantly proceeded to trial. On the day the trial began, October 9, 1973, police security, the most massive in the history of New Jersey, was virulent, jamming the streets surrounding the Middlesex County Courthouse and saturating the courtroom. On the previous day, Assata had been convoyed the 7.5 miles from the workhouse to the Middlesex County Jail adjacent to the courthouse and was entombed in the basement, a large, windowless, vermin-infested room where she was on 24-hour neon-lighted display and under heavy guard. She was the only woman who had ever been incarcerated in the 56-year-old men's jail. Sundiata was also there, separated from the other prisoners somewhere above the first floor. Preparations for the armed occupation of the city of New Brunswick had been underway for some time as members of the Sheriff's Department, the New Brunswick Police Department, and the police and unofficial plainclothes personnel from New York's major case squad and the FBI joined forces. A reaction team of 10 men from the state police and the city police department established a command post in City Hall from where they monitored activity in the entire city and were prepared to deal at a moment's notice with any bomb scares that might occur. They also prepared for an anticipated raid on police headquarters for securing arms. Guards were assigned to the judge and his family, members of the prosecutor's office, and each juror as he or she was selected. Closed-circuit television cameras and microphones were installed on each of the courthouse's 5 floors and in the courtroom where the trial was held. Only 20 spectators were allowed in the 70-seat courtroom. Each was issued a pass and, after screening by a metal detector, was hand-searched. Assata and Sundiata, handcuffed and in leg irons, flanked by a small army of police, walked the short distance from the jail to the back door of the courthouse through a mob of reporters, a battery of flashlights, and curious onlookers straining to get a glimpse of the notorious pair. It was an atmosphere hardly saturated with the presumption of innocence and could not have helped but influence any juror with the defendant's guilt. As soon as a trial begins, defense lawyers shift into another gear. All the probing maneuvers are over, and well-honed reflexive reactions to developing evidence emerge. You have to read fast, analyze fast, memorize testimony fast, and raise objections fast. The rules of evidence must spring to your mind automatically, enabling you to provide the legal basis for your objections as quickly as you make them. The beginning of the trial is the point when everything you have learned throughout the long pretrial phase has been integrated and solidified, and when your years of experience as a trial lawyer blanket you with the security of familiarity. It is the time to check your appearance, cut your hair, or manicure your nails, time to eliminate mannerisms that will attract the jury's attention to you rather than to the evidence being presented. You know that how you dress becomes as important as your legal presentations. Your concentration is keyed on each witness, probing for his or her weaknesses and jumping all over his or her hesitations. You give instructions to the defendant you represent, when to whisper to the lawyer and when to remain impassive in the face of the most damaging evidence. You are on center stage. It is what I call showtime. My clothes were in sharp contrast to Assata's. She had asked her mother to buy ankle-length African dresses and jelliest African head wraps to match, and they were so beautiful and colorful. At each time she appeared in court, every newspaper described what she wore as if the trial were an item on the fashion pages. I wore simple slack suits in navy blue, black, brown, gray, or tan. Sundiata's wife had brought him wonderful-looking African dashikis, and the two defendants were radiant in the drab surroundings of the heavily guarded courtroom. Jury selection began on October 11th. Jurors can be selected in different ways, depending on the rules of the jurisdiction. In New Jersey, as in federal courts, the judge conducts the voir dire, asking jurors questions that he or she has approved from a list prepared by the defense and the prosecution. In New York State, the lawyers conduct the voir dire. The defense and prosecution are each given a certain number of peremptory 103 challenges, in our case 10 each for Assata and Sundiata and 10 for the prosecutor, whereby a prospective juror can be disqualified without a reason given. The judge has the sole discretion to remove a juror for cause where there is clear evidence that the juror is not qualified to sit on the jury, either for express bias or other reasons. And there is no limit to the number of jurors who can be removed when this determination is made. Judge Johnny Bachman was a civil man, courteous and reasonable, implacable, and he always displayed a model judicial temperament, whether he ruled for or against a motion. For example, unlike other judges in later trials, he refused to cite Assata and Sundiata for contempt when they remained seated as he entered the courtroom, to the chagrin of the prosecutor, a squat man, ugly in face and in manner. When Assata objected to the tone of voice the judge used when questioning a juror, complaining that it suggested the answer and adding, "The same rules that apply to the lawyer should apply to the court," he quietly responded, "Your objection will be noted." He manifested a fairness that enabled him to reverse his own decisions. For example, when the trial began, he ordered spectators banned from the courtroom during jury selection, after hearing our arguments protesting that he was creating Star Chamber secret proceedings. He changed his position and stated on the record that the security precautions he had in mind were not as important as the perception of unfairness that closed hearings would suggest. And when we opposed the limited number of spectators allowed in the courtroom, he permitted all seats to be filled. The first prospective juror to be questioned was a typical member of the jury panel. We had asked that, pursuant to the 1973 U.S. Supreme Court in Hamvey, South Carolina, the judge inquire into racial attitudes. This juror, when asked about the racial composition of his neighborhood, said it was all white and unequivocally stated that he would not have a black person living next door to him, describing a process where blacks make it a point to move into certain neighborhoods to break it up. By the third day, only one of the 16 jurors to be selected had been tentatively chosen by Bachman. When he learned that the jurors were discussing the case among themselves in the jury room and referring to newspaper articles, two things the judge had specifically instructed them not to do, he dismissed the entire panel. A new panel was installed and the voir dire staggered slowly forward. Then, on the 5th day, a prospective juror revealed that a friend of the dead trooper was on the panel discussing the case with the others. In addition, the prospective juror revealed the unanimous opinion of the entire panel that if she's black, she's guilty. We immediately asked for a mistrial, which Bachman denied, but he dismissed that panel as tainted and called 600 and 50 more. The following day, the first 6 jurors recited what was transpiring among this new group. They were openly reading the newspapers, discussing the case, and expressing their opinions that both Assata and Sundiata were guilty. The spectators were stunned into silence as they listened to each prospective juror's bald admissions and perceived the horror story unfolding in the back room where the jury panel sat waiting to be questioned. Bachman denied our second motion for a mistrial, stating that just because these panels were tainted, he could not believe they were representative of the entire county. Before he called yet another set of jurors, however, he agreed to postpone the case to afford us time to prepare a new motion for a change of venue to present to the administrative judge. On November 1st, 1973, Judge Jurowski granted our motion for a change of venue, moved the trial and the selection of jurors from Middlesex to Morris County, and set a new trial date of January 2nd, 1974, to allow the county time to make security arrangements. He now admitted that it was almost impossible to obtain a jury here comprised of people willing to accept the responsibility of impartiality so that defendants will be protected from transitory passion and prejudice. While we applauded the removal of the case from Middlesex County, we were appalled at Jurowski's choice. Morris County was one of the richest counties in the state, with the fewest blacks and some of the most conservative voters in the country. Saddled with this reversal of fortune, we immediately swung our collective energies into substantiating the fact that we could not get a fair trial in Morris County, and we moved yet again for a change of venue to Essex County, which had a larger percentage of black residents eligible for jury duty. We raced relentlessly against the deadline, searching for unimpeachable authorities to support our motion. Charles Gray, one of the members of the National Black Assembly of New Jersey, elected from Middlesex County, provided us with the 105 demographics for each county in the state. We learned that of Middlesex's total population of 583,813, only 19,248 were black, and the total number of registered voters, both black and white, was 230,569. Morris County had the highest percentage of registered voters, 195,436 out of a population of 303,454. It also had the smallest number of black residents, 6,954. Essex County had the largest population of any county in New Jersey, 929,986, as well as the largest number of black residents, 270,736. Its registered voters numbered 429,762. The politically sophisticated city of Newark was in Essex County. Its voters had elected Imamu Amiri Baraka, Kemu Temtezi, and Hope Jackson as its assembly representatives. Our contention was twofold. The first was the constitutional principle mandating that criminal defendants be tried by a jury of their peers. While certainly there isn't an identical experience shared by all black people, nevertheless life is certainly more similar among black people than it is between blacks and the majority of Morris County whites. Second, despite the apparent objectivity of the grand and petty jury selection process set forth in the official manual on the selection of grand and petty jurors, State of New Jersey, and heralded as fair by Jurowski, the process was weighted against the possibility that black jurors had an equal chance of being randomly selected for jury duty. We were fortunate to obtain the assistance of Professor Donald Payne, who had a Ph.D. from the University of Indiana and was teaching a graduate course in statistical data analysis at NYU. Using the demographic information we provided him and the juror's manual, Payne prepared a report on the statistical probability of black members being represented on the petty juries of Morris, Hudson, and Essex counties. Both Norman Latimore, the Democratic County Chairman of Morris County, and David Edwards, a member of the City Council of Morristown, Morris County, submitted affidavits attesting to the unpublished statistics of the number of registered black voters in Morris County from 2,000 to 3,000, which Payne used in his evaluation. We attached these affidavits to Payne's report and submitted both with our motion. Payne's conclusions, supported by 14 pages of statistical analysis, profiled in graphs and charts, was that the probability of black jurors on any panel of 16, the number of trial jurors, was none in Morris County. He also described the inherently unfair and arbitrary procedures for juror selection as mitigating against an impartial selection system. For example, certain professional people who could request to be excused from jury duty were removed from the total voter registration list, thereby impeaching the system of random selection. Once a juror had served, he or she too was removed from the list. Additionally, Payne learned that jurors were not chosen from among all the registered voters, but only from those voters who returned questionnaires sent to them by the county commissioner. The assignment judge had the authority to remove from the list any person who did not return the questionnaire and replace that person with someone of his or her choice. Obviously, if the judge so chose, he or she had the power to bias the jury by this simple method. Payne concluded, "The power is particularly potent in the instance of minority representation. Since few representatives of minorities will appear on a jury selected at random, if these are stricken by the assignment judge, it is unlikely that a fellow representative will take his place." We also attached to our motion a report of a survey to determine attitudes and biases in Morris County, conducted by the Center for Responsive Psychology, headed by Dr. Robert Buckhout, professor of psychology at Brooklyn College. The center surveyed more than 500 registered voters during the first 2 weeks in November 1973 and concluded, "There is such a high degree of negative publicity of Ms. Chesimard and her background of arrests and charges, and so high a percentage of potential jurors already prejudiced, that there is no predictable probability that a fair jury could be selected in Morris County, as the presumption of innocence has been so compromised among potential jurors that, failing to prove her innocence affirmatively, she would certainly be convicted." His survey showed that 76% of the voters questioned believed that both Assata and Sundiata were guilty. As the entire defense team was racing to prepare this critical motion for submission before January 2, 1974, Judge Lee P. Gagliardi of the U.S. District Court for the Southern District of New York issued an order on November 28, 1973, demanding that Assata be returned to the state of New York to stand trial for the Bronx bank robbery of September 1, 1972. Trial was to begin immediately. Chapter 11. No matter how widely publicized criminal accusations are, the only way a person can be prosecuted for a felony, such as a bank robbery, is by grand jury indictment. Once the indictment is filed, the defendant appears before the court and enters a plea of guilty or not guilty, a procedure called an arraignment. If the plea is not guilty, a date for trial is set, and the trial proceeds within a specified period of time determined by the rules of each jurisdiction, unless it is postponed for a good reason. Between arrest and the time a petty trial jury arrives at its verdict, the defendant is presumed to be innocent, a presumption that can be overcome only by evidence that proves guilt beyond a reasonable doubt. After Assata's arrest in New Jersey on May 2, 1973, indictments against her began to pile up. Arrests of alleged members of the BLA, official police department announcements promising future arrests, and police shootouts following stakeouts of alleged BLA members multiplied with accelerated frequency. In the early morning hours of June 7th, Andrew Jackson, whom the police had called a leader of the BLA over the past 2 years, was captured quietly in his New York City apartment along with his girlfriend, Denise Oliver, by FBI agents and New York City detectives. He was arrested on a federal warrant charging him with the August 23, 1971 Queens bank robbery. Named as co-defendants were Assata, Mark Holder, Igni Ruth Giddens, and John Leo Thomas. Another federal warrant had been issued for his arrest for the April 17, 1971, murder of Samuel Lee Napier, West Coast circulation manager of the Black Panther Party's newspaper following a split with the East Coast Panthers. He was also wanted for his escape from the DeKalb County, Georgia jail on December 12, 1971, after his arrest in a supermarket holdup, and was wanted for questioning in the murders of police officers Gregory Foster, Rocco Laurie, Waverly Jones, and Joseph Piagentini. Additionally, he had been indicted in the January 2, 1973, murder of the Brooklyn drug dealer along with Assata, Melvin Kearney, and Twyman Myers, and on July 20, 1973, was identified in a lineup as a participant in the ambush slaying of two Queens policemen, Michael O'Reilly and Roy Polina, for which he was later indicted along with co-defendants Avon White, Jeanette Jefferson, Robert Hayes, and Assata. Later on the day that Andrew Jackson was arrested, Fred Hilton was surrounded on a Brooklyn street and arrested as he was about to enter a building that had been staked out by police and the FBI on an informer's tip. A federal fugitive warrant had been issued for his arrest, along with the arrest of Assata and Avon White for the September 1, 1972 Bronx bank robbery. According to the New York Times, Hilton was listed as one of 8 wanted members of the BLANA. Recent intelligence advisory by the police department. On June 9th, the Long Island Daily Press devoted a 4-page spread entitled Dragnet for Black Lib Army Trio Titans and Probe of Cop Killings to predicting the early arrests of members of the BLA, particularly Melvin Kearney, Twyman Myers, and Avon White. Photos of the wanted 3, plus those of Jackson, Hilton, and Assata, were featured on one page. On June 12th, Assata was indicted for the September 1, 1972 Bronx bank robbery along with Fred Hilton and Avon White. On July 20th, Assata was arraigned for the August 23, 1971 Queens bank robbery. On the same day, Jackson, in addition to appearing for the lineup in the O'Reilly and Polina murders, was also arraigned in Queens State Court for the murder of Napier. In a press conference on August 24th, the Brooklyn District Attorney, Eugene Gold, announced that indictments had been returned against 9 members of the BLA for additional crimes committed in Brooklyn, fulfilling the prediction of the Long Island Daily Press. The sensationalized reportage gave the names of the 9 and released their pictures to accompany the story. Andrew Jackson, Melvin Kearney, and Twyman Myers were indicted along with Assata for the January 2, 1973 murder of a Brooklyn drug dealer. Fred Hilton was indicted for possession of weapons found when he was arrested on June 7th. Victor Cumberbatch, already arrested for the murder of a New York City Transit patrolman on June 5, 1973. Avon White and Robert Hayes were indicted for a March 7, 1973 robbery of $350 from a Key Food in Brooklyn. Ronald Myers was indicted along with Assata and Melvin Kearney for the December 28, 1972 kidnapping of a Brooklyn drug dealer. All were in police custody with the exception of Kearney, White, Hayes, Ronald Myers, and Twyman Myers. Kearney, White, and Hayes were arrested on September 12th by a large force of New York City police and FBI agents in a raid on a Bronx tenement the police believed was the headquarters of the BLA. Acting on a tip, they cordoned off the entire block and stationed themselves on the roof and in the basement of the building. Dozens of shots were fired as the police team crashed through the door of the suspected ground floor apartment, and 3 policemen were injured. Ronald Myers voluntarily surrendered to the police on August 25th, the day following Gold's press conference during which he had identified Myers as being wanted. On September 3rd, Herman Bell, the last of 5 alleged members of the BLA indicted in the 1971 murder of policeman Waverly Jones and Joseph Piagentini, was arrested after a stakeout in New Orleans, surrendering without a struggle when the car in which he was sitting along with his wife and 2 children was surrounded by a massive force of New Orleans police, FBI agents, and New York detectives. The others who had been indicted for the murders were Albert Washington, Anthony Bottom, and 2 brothers, Gabriel and Francisco Torres. When Twyman Myers was killed by police on November 14th in an ambush shootout on a Bronx street after several days of a stakeout following a tip, Police Commissioner Cawley announced that the last of the leaders had been killed and that Myers' death had effectively broken the back of the BLA. He was the 7th alleged member of the BLA to die in a police shootout. I was representing Assata on all of the cases for which she had been indicted, appearing with her at arraignments and filing the usual pretrial motions, but the multiplicity of indictments disturbed me less than the growing number of alleged BLA members being arrested. And I was haunted by the prospect that one or all of them would plead guilty and falsely testify against her in exchange for a light sentence or other consideration. The September 1st, 1972 Bronx bank robbery trial proved that my apprehensions were well-founded. There had been 2 indictments for this bank robbery. The first, returned by the federal grand jury on November 21st, 1972, charged Louis Gesimard, Assata's former husband, Paul Stewart, John Rivers, and Woody Green with having committed the robbery. The trial began on May 29, 1973, and ended in acquittal a week later. John Rivers had suspiciously pleaded guilty on the night of the robbery and testified for the government against Gesimard and Stewart during the trial. The second indictment was returned by the grand jury on June 12, 1973, and charged Assata, Fred Hilton, and Avon White with the crime. Assata was arraigned following the second indictment on August 3, 1973, before Judge Lee Gagliardi of the U.S. District Court for the Southern District of New York. She pleaded not guilty and the trial was postponed until the termination of the New Jersey trial. During the pretrial conference held on September 26th, I explained that the New Jersey trial had been delayed because of the many motions still being decided. Gagliardi extended the postponement of the Bronx bank robbery trial, and when a firm date of October 9th was set for the New Jersey trial, I wrote a letter so advising him. When the venue was changed to Morris County on November 1st, it never occurred to me that the Bronx bank robbery trial or any other would intervene before the New Jersey trial date of January 2, 1974. So when Gagliardi called me in for a pretrial conference on November 27th, claiming surprise and annoyance because he had just learned of the postponement in New Jersey and ordered the trial in his court to begin immediately, I was stunned. No one who had read the newspapers, and certainly no one in the legal profession, could have been ignorant about the postponement or the fact that it was caused by the change of venue. It was clear that Gagliardi was lying. And it was equally clear that he was trying to conceal his real reason for rushing to trial. Co-defendant Avon White had pleaded guilty before Gagliardi on November 24th, and although it was not reported by the media, had struck a deal with the U.S. Attorney and Gagliardi whereby he had agreed to testify against Assata and Kamal Fred Hilton. It was clear to me that White had been pressured into an early plea bargain to facilitate commencement of this trial before January 2, 1974, when the New Jersey trial was to begin, and before White recanted. I explained to Gagliardi at the November 27th pretrial conference that from the time of Assata's arrest in May until the first week in August, I had not been able to prepare for even the New High Jersey trial because I had not been permitted to confer with her privately, and that even though we were not now technically on trial, I was actively engaged in the ongoing preparations and investigations to challenge the change of venue to Morris County. As I talked to this disagreeable, unreasonable, red-faced little man, a Nixon appointee to the federal bench and a right-wing conservative Republican resident of Westchester County, New York, a county strikingly similar in all its characteristics to Morris County, one realized that he had no intention of postponing the trial. Despite the fact that he had just granted a postponement for U.S. Attorney General John Mitchell and former U.S. Secretary of Commerce Maurice Stans. They were on trial in the so-called Vesco case, charged with hampering a Securities and Exchange Commission investigation into Vesco's financial affairs in return for a large contribution by Vesco to the 1972 Nixon campaign. Stans had also been Nixon's chief fundraiser in that election. This was the only indictment they faced at the moment, although Mitchell was later indicted for involvement in the Watergate break-in and cover-up and with their battery of high-priced and well-connected lawyers. Their claim that they needed more time to prepare for trial certainly was no more justifiable than Assata's very legitimate reasons. Gagliardi rejected every argument I advanced. Trial was to proceed immediately, and that day he issued an order transporting Assata to New York State jurisdiction. I barely had time to sprint to the Middlesex County Jail to tell her she would be moved the next day to stand trial in the Southern District Court. She listened to me speechless and expressionless. Her rage exploded the next day when she appeared before Gagliardi, and he refused to grant an adjournment of even a few weeks. This was Wednesday, November 28th, and he scheduled the trial for the following Monday, December 3rd. I worked around the clock to research and prepare an appeal to the U.S. Court of Appeals from Gagliardi's decision, filing it on Friday, November 30th. The hearing before the appellate court was heard on the next court date, Monday, December 3rd, the same date Gagliardi had scheduled the trial to begin. During my research, I had become aware of a major legal obstacle to a favorable decision. The Court of Appeals had no jurisdiction to postpone the trial, even if it did consider Gagliardi's ruling to have been arbitrary. At best, it could strongly urge him to reconsider, as it had done successfully in the Mitchell-Stans case. I argued in my petition that Assata's special circumstances required the court to make the same recommendation to Gagliardi. In its opinion denying the petition, the Court of Appeals pointed out the differences in the two cases that it claimed precluded it from making the same recommendation. It stated, "A comparison of the two cases is instructive. The indictment in Stans was 46 pages containing 16 counts and was supplemented by a 60-page bill of particulars. The indictment in this case is 3 pages containing 3 counts. Our dissenting colleague in Stans properly described that case as without precedent in the history of the country and the charges as somewhat novel. The charges here, while serious, are not unusual." The appellate court also pointed out that while Mitchell and Stans had made the request for adjournment jointly, Robert Bloom, Kamau's attorney, had repeatedly stated his client's readiness to stand trial, even if Kamau's trial were to be held separately from Assata's. In fact, as early as June and again in late September, while I was requesting a postponement in New York, Bloom had made a motion for severance and an immediate trial. A motion to sever a co-defendant to have a separate trial for each was one of 2 strategies used by some of the lawyers representing Assata's co-defendants. Separate trials for the other defendants would avoid the taint of negative publicity attached to Assata, which at the time seemed to guarantee conviction. The other reason was to slander and absent Assata with impunity for the benefit of other defendants. In Bloom's first written motion for severance on July 6, he stated, "It is anticipated that the evidence against defendant Hilton will consist essentially of the testimony of an alleged co-conspirator, one John Rivers, a convicted felon. It is essential that in such circumstances every safeguard of the defendant's right to fair and unprejudiced trial be maintained. One very likely area of prejudice may arise if defendant Hilton must proceed to trial with defendant Joanne Chesimard. Many newspaper articles and magazine articles have appeared with regard to Joanne Chesimard and her alleged radical activities in the past year or more, and there has been extensive television and radio reportage as well. As to Joanne Chesimard, it is respectfully U.S. submitted that it would be difficult in the near future to afford a truly fair trial to her, and necessarily to anyone co-indicted in the same trial." While Bloom's motion to sever Kamau from Assata's trial raised questions in my mind about the feasibility of our presenting a common defense, I never suspected that he might be dangerous to Assata. Then I read the earlier May trial transcript that the assistant U.S. attorney, John H. Gross, gave me when Assata was arraigned on August 3, 1973, material he was not obligated to disclose to the defense. Jesse Berman, Bloom's associate, represented Louis Chesimard. Louis was a college graduate with a respectable job who had been honorably discharged from the Air Force. He was clean-cut, was remarried with a child, and had no criminal record. Relying on all of these qualities, which from a conventional perspective suggested a person of good character, He testified in his own defense, a rare occurrence in any criminal trial, regardless of the defendant's background. The transcript revealed that under Berman's carefully orchestrated direct examination, Chesimard testified that Joanne Chesimard was a fugitive. That during FBI questioning of him before he was arrested, they had told him, "When we catch up with her, we're going to kill her." That ever since Assata had been a fugitive, she had always worn disguises, and that she always ran with BLA members and was always armed. The implications of his testimony were clear to the jury. Assata, a dangerous fugitive who always carried a gun and was always disguised so that even one who knew her well could pass her in the street without recognizing her, had forced him to obtain one of the vans allegedly used in the robbery. He was an unknowing and unwilling participant. His entire testimony reinforced the violent picture of Assata so well portrayed by the media. But of course, his trial began on May 29, 1973, after Assata had been captured in the shootout and her dangerous presence was safely behind bars. Both he and Paul Stewart were acquitted. Gagliardi was the trial judge. I tried to repress my suspicions about Bloom. Was it fair to attribute Berman's trial strategy to him? If, in fact, Chesimard's testimony could be justified as trial strategy, was Bloom's severance motion an understandable move in the best interests of his own client? I didn't know Bloom personally, but I did know that he had been one of the attorneys in the Panther 21 trial and was the lawyer for Dhoruba bin Wahad, Richard Moore, Victor Gumberbatch, and Andrew Jackson. I tried to communicate my concerns about Bloom to Assata on more than one occasion, but the forced trial was so traumatic that she had neither the time nor the inclination to criticize her co-defendant's lawyer. In addition, in Assata's mind, Bloom was a movement lawyer and therefore to be trusted. In any event, I was stuck with him as co-counsel, regardless of my doubts, but I remained wary of him. It was not until after the Bronx bank robbery trial that the full dimensions of Bloom's treachery were revealed to me, and my suspicions that Bloom was Assata's enemy were confirmed. On October 28, 1976, during a hearing before Judge Frank Vaccaro to set the rules for Andrew Jackson's pretrial lineup in the Brooklyn drug dealer murder, Bloom displayed a surprising willingness to rely on the credibility of Avon White, the informer who had pleaded guilty in the Bronx bank robbery case and who had testified against Kamau and Assata. Bloom advised the court that White had given him a handwritten statement to the effect that Melvin Kearney had confessed to committing the murder and to afterward removing the victim's identification cards from his body and giving them to Joanne Chesimard and Woody Green. Green had been killed in a shootout with police before the indictment had been returned, and Kearney had died in 1975 while attempting to escape from the Brooklyn House of Detention. In his oral argument, Bloom not only insisted that Jackson was innocent, but stated that he could prove the guilt of the real perpetrators, Assata, Kearney, and Green. Bloom told the court, "I want to prove that it was Chesimard and Green and Kearney that participated in the sharing of the identifications of the deceased. What I'm trying to do is this. It will be my effort to show the jury that certain people other than Mr. Jackson committed the crime." And it was revealed at the Queens Bank robbery trial, in which Jackson was Assata's co-defendant, that Bloom employed an even more vicious strategy calculated to convict Assata. What I did know at the time of the Bronx bank robbery trial, however, was that representation of those who were called members of the BLA was how to bonanza for young white lawyers like Bloom and Berman trying to hone their skills, establish a reputation, and gain the visibility guaranteed by extensive media coverage. To be assigned to criminal cases of indigent defendants, as most of the alleged BLA members were, these lawyers became part of the panels established in state and federal jurisdictions. While the payment they received did not compare with fees they might have garnered for representing other alleged major crime figures, they were paid something. In addition, they were entitled to services that would cost a privately retained lawyer and his or her client about $1,000 a day, free daily copies of trial transcripts, and the services of investigators and other legal experts. My objection to these young white panel lawyers was specific. They formed a small in-group cadre and shared an obsession with BLA cases. They were as suspect to me as was the fact that the same judges were repeatedly assigned from the random selection wheel to preside over BLA trials. Robert Bloom, Jesse Berman, and Judge Gagliardi exemplified my concerns. On the afternoon following the Court of Appeals decision not to encourage Gagliardi to postpone our trial, Gagliardi called up the first 150 prospective jurors. And the battle was on. Assata refused to permit the judge to question them. As soon as he began a question, she interrupted him by standing up and demanding an adjournment, stating clearly to the jurors that she had not had time to prepare for the trial. Each time, Gagliardi had her removed from the courtroom by the marshals. At the end of the third day, Gagliardi still had not been able to select a jury, and both Assata and C.O.W.S had been taken from the courtroom on 10 separate occasions. As Assata was forcibly evicted, she accused Gagliardi of having made deals, of being bigoted, of having been bought and paid for, and of subjecting her to a lynching. She said he was like a 2-year-old baby, so unintelligent as to force a lawyer and client to go to trial when they were not prepared, charging that he was bought and paid for by big business and had no concern for justice or black people or for poor people or for any defendants except Mitchell and Stans. Finally, to avoid the brutality of the marshals, she would rise as they approached, saying in her usual quiet voice, "I will remove myself," and then stalk regally from the courtroom, trailed by C.O.W.S and the marshals. Gagliardi threatened to have the two defendants gagged, bound, and shackled if they continued their outbursts. They continued, and he asked Bloom and me which form of containment we preferred. Receiving no response, he made the decision himself and banned them from the courtroom on December 4th. I refused to proceed in Assata's absence. I walked out of the courtroom, and that afternoon Gagliardi appointed another lawyer for Assata as alternative counsel, who was in place the next afternoon when I returned. Although he banned Assata and C.O.W.S on occasion, he permitted them to return on their promise to behave. When they were again quickly ejected, I again demanded Assata's presence and again left the counsel table, stating that I could not continue in her absence. Gagliardi shouted to the marshals, "Lock that door," as I approached the exit from the courtroom, and cited me for contempt. That was on December 7th. The next day, the New York Times, in its typical selective fashion, made no comment about the unfairness of the trial, but instead headlined its editorial with the words "Order in Court" and said, "The disruptive behavior of Joanne D. Chesimard and Fred Hilton during their trial on bank robbery charges once again raises the issue of the defense lawyer's responsibility for a client's conduct." Instead of urging Mrs. Chesimard to desist from her disgusting verbal attacks on United States District Judge Lee P. Gagliardi, Miss Evelyn Williams, the defendant's counsel, exacerbated the situation by trying to walk out of the courtroom in defiance of the judge's order to return to the defense table. Courtroom decorum is not a mere matter of social niceties. Without it, judicial procedures deteriorate, and society is eventually deprived of the benefits of a fair resolution of its grievances. Efforts to turn criminal trials into ideological circuses are as intolerable as the misuse of the courts for the purpose of persecuting political dissenters for alleged conspiracies. In either case, it remains the defense lawyer's professional and moral duty to help maintain court decorum rather than condone a client's disruptive protest, regardless of the latter's motives. The point at issue remains nevertheless the same. It is essential that officers of the court, specifically including defense lawyers, comply with the judicial protocol that forms the cement of the rule of law itself. With no other recourse available, both Assata and C.O.W.S agreed that the only role the lawyers could take was to remain mute throughout the trial, to make no opening or closing statements, to cross-examine no witnesses, and to participate in no way in the trial, hoping to use Gagliardi's decision to obtain a reversal on appeal of the inevitable conviction. When they were not in the courtroom, Assata and C.O.W.S were in the holding pen just behind the courtroom, where a loudspeaker had been installed. They emerged at selected times, as when Avon White and John Rivers testified, called them both bought and paid for liars, and left. There were protests from the many spectators. On one occasion, when they chanted, "This trial is a racist frame-up. How can you have a trial without a defendant?" The spectators were ordered to leave the courtroom and several were arrested. The government rested its case after 1 day of testimony, and within hours after jury deliberations began, the jury returned, announcing they were hopelessly deadlocked and could not reach a verdict. They wanted to know why the defense lawyers claimed they were not prepared for trial, as well as what had happened in New Jersey and why there had been no attorney participation in the present trial. Gagliardi told them that none of what had transpired was any of their concern and that they should limit their deliberations to the evidence. They asked permission to question Assata and C.O.W.S, reflecting the state of their confusion, and their request was denied. Only Bloom felt that his client should abandon his Fifth Amendment rights against self-incrimination and voluntarily respond to questions from the jury. On the third day of jury deliberation, a mistrial was declared because the jury was deadlocked. We later learned that one black juror had held out for acquittal because the refusal of defense counsel to participate gave validity to Assata and C.O.W.S charges that they were being denied a fair trial. We awaited the second trial, scheduled to begin immediately before another judge, with strange optimism because the prosecutor had presented all of his evidence. There had been no surprises, with the exception of Rivers' testimony from the May trial, and our chances of acquittal seemed at least possible. We knew that White and Rivers would command no more credibility before a different jury. In addition, the assistant U.S. attorney, Peter Trubner, who had also prosecuted the May trial, had told the jury in his opening statement that the government has no fingerprints, no pictures of the defendants, no guns, no money, or anything like that. I knew that bank surveillance pictures had been taken but were not used during either the May trial or this one because they were so fuzzy that identification of anyone was impossible. And Trubner's admission to the jury that there were no photos simply meant that he would not introduce them into evidence because no one could be identified. But I also knew that the government will shape testimony to fit any conclusion it wants drawn, and I was not so sure that those photos would not suddenly emerge during the second trial, with White making an identification of Assata in the bank. Rivers had not been asked to even look at the photos in the May trial, and it was logical to assume consistency on the part of the prosecutor and to reason that he would not ask him suddenly to identify them now. Because under no circumstances could C.O.W.S be so fingered. In all previous testimony, C.O.W.S was placed outside the bank waiting during the progress of the robbery in a getaway van. The only purpose of showing the photographs, which had been released to us with other potential evidence, would be to claim that one of the shadowy figures was Assata. So when Bloom, C.O.W.S attorney, announced that he was going to introduce them into evidence, I was outraged beyond my ability to describe. I had been spoiled by my association with two great trial lawyers in New Jersey who always worked in tandem, always complimented each other's special talents, always were willing to concede that a decision unilaterally made was not advantageous to both defendants, and always, in times of honest disagreement, easily resolved conflicts. For example, when the New Jersey jury selection process began, Ray had decided, along with Judge Bachman, to seat only 20 spectators and consented to an in-camera voir dire held outside the public courtroom. After discussion with Sundiata, Charlie, Assata, and me, he understood the political necessity of an open courtroom and corrected his position with a brilliant argument before Bachman. And he was successful in reversing that decision. There were other instances, but the point is that we talked about strategy with each other in an open fashion and reached collective agreements. Assata was adamant that the photos posed no threat to her but was unable to explain their advantage. When she insisted that I listen to what Bloom had to say, the burden of the months I had worked around the clock and the suddenly blatant demonstration of his treachery and Assata's refusal to see it as such crashed around me and unleashed my fury. Among other things, I told her that she could proceed for the balance of the trial with Bloom as her lawyer and that I was removing myself from the case. I felt that her failure to understand the significance of Bloom's stated intention to admit the photos into evidence was a clear rejection of my judgment and my ability as a lawyer. I could not prevent tears of anger as I made my motion to be relieved of the responsibility of representing her. Arnold Baumann, the newly assigned judge, ordered the trial to begin on the day following the hung verdict, granted my motion to withdraw, and permitted Florence Kennedy, the well-known black feminist attorney, to be co-counsel with Assata, who cross-examined White and delivered her own summation. I thought this form of participation was an excellent maneuver, for it allowed Assata, a personable and convincing defendant, to reinforce her innocence directly to the jury without undergoing rigorous cross-examination. Few defendants can carry it off, but when they can, there is no one better to explain to jurors, none of whom have ever been convicted of a crime, the evils of a judicial system embedded in an evil societal system. In the second trial, there were no outbursts, no banishments from the courtroom, and total application to every legal detail. Prior to her arrest, Assata had never attended a trial, and her limited knowledge of the practice of law came essentially from my heated comments to her during her adolescence when she lived with me. I would return home with daily complaints about the maze of inequality in which black defendants were trapped, and she would listen in complete agreement, designating me the last angry woman. My fears about the photos had been right. Although Bloom did not introduce them into evidence, interestingly enough, Trubner did, and Avon White suddenly was able to identify one of the figures in the bank as Assata. The jury, questioned after their verdict of acquittal, said they had reviewed the surveillance photo over and over again. It had been the only piece of evidence they had to resolve in order to acquit because they had completely discredited Rivers, E's, and White's testimony. The jury was finally persuaded that the figure in the photo was not Assata because White had described her as wearing overalls and the figure was wearing a jacket, a slim thread from which acquittal had dangled. The day after the verdict, on December 29, 1973, Assata was transferred to Morristown in Morris County to continue the New Jersey trial. I have pondered the situation many times, and I have come up with a rationale for the position Assata took, which had nothing to do with disagreeing with my analysis or agreeing with Bloom. Instead, her need to maintain cohesiveness with Kamau, whether or not it meant her sacrifice in the process, was of paramount importance. It was a political decision she took but did not share with me, unfortunately, because I at least would have understood. Although, let me be perfectly clear, I would never have agreed with the decision whether or not it was politically correct. In other political cases where I have been asked to represent one of multiple defendants, my first question is always, is Bloom one of the attorneys? If he is, count me out.
Katherine Massey Book Club, Context of White Supremacy. That will wrap up Chapter 11. We will pick up the second session on Chapter 12, very beginning, Chapter 12, pushing right on through this book, which is not too long. We are over the halfway point today, so max 4 sessions left. Probably not even that much. Number to dial, 720-716-7300. The code 564-943 #. Press star 61 if you would like to participate. Number again, 720-716-7300. The code 564-943 #. Press star 61 if you would like to participate. The email untiljustice@gmail.com. untiljustice@gmail.com. COINTELPRO. So much I could add in from that one particular, so I guess we heard a couple chapters, that first audio segment that we heard last week, the book mentioned that Assata, she wrote and made a recorded message that was played on black radio stations, published in black newspapers right after the shootout on the Jersey Turnpike. And I said that, hey, you can go Black Scholar, you can get the publication, or you can get the download of this report, probably a number of other articles too, because it was published in so many different outlets and journals during this time period. Assata Shakur also published other reports, not just the one where she talked about being innocent and the police just practiced racism, got this whole COINTELPRO operation to come and terrorize her. She also published Women in Prison, How We Are. Now, this is from Black Scholar. I suspect this might have been published in other journals as well, but Black Scholar, April 1978. The report title again, Women in Prison, How We Are. I'm not going to read the whole thing because it's kind of lengthy, substantially longer, in fact, than the report that she wrote just talking about her arrest and how they framed her and this is all messed up and blah, blah, blah. This report, I'll just give you like the first page. We sit in the bullpen. Isn't the World Series today? They got the baseball. We sit in the bullpen. We are all black. All restless, and we are all freezing. I don't like that cold. When we ask, the matron tells us that the heating system cannot be adjusted. All of us, with the exception of a woman, tall and gaunt, who looks naked and ravished, have refused the bologna sandwiches. The rest of us sit drinking bitter, syrupy tea. The tall 40-ish woman with sloping shoulders moves her head back and forth to the beat of a private tune while she takes small tentative bites of a bologna sandwich. Someone asks her what she's in for. Matter-of-factly, she says, "They say I killed some nigga. But how could I have when I'm buried down in South Carolina?" Everybody's face gets busy exchanging looks. A short, stout young woman wearing men's pants and men's shoes says, "Buried in South Carolina?" "Yeah," says the tall woman, "South Carolina. That's where I'm buried. You don't know that? You don't know shit, do you? This ain't me. This ain't me," she kept repeating. "This ain't me," until she had eaten all the bologna sandwiches. Then she brushed off the crumbs and withdrew, head moving again back into that world where only she could hear her private tune. Lucille comes to my tier to ask me how much time a C felony conviction carries. I know, but I cannot say the words. I tell her I will look it up and bring the sentence charts for her to see. I know that she has just been convicted of manslaughter in the second degree. I also know that she can be sentenced up to 15 years. I knew from what she had told me before that the district attorney was willing to plea bargain 5 years in exchange for a guilty plea to a lesser charge. They love those plea bargains. Her lawyer felt she had a case, specifically medical records, which would prove that she had suffered repeated physical injuries as the result of beatings by the deceased, and as a result of those beatings on the night of her arrest, her arm was mutilated. She must still wear a brace on it, and one of her ears was partially severed, in addition to other substantial injuries. Her lawyer felt that her testimony when she took the stand in her own defense would establish the fact that not only had she been repeatedly beaten by the deceased, but that on the night in question, he told her he would kill her, viciously beat her, and mauled her with a knife, but there is no self-defense in New York State. last paragraph that I'll read. The district attorney made a big deal of the fact that she drank, and the jury, affected by TV racism. What is that? That's what it says, but I don't. What is TV racism? It's 2025, now on 2026. Do they have Netflix racism now? Streaming racism? YouTube racism? What you think? I never heard of that one. TV racism. Y'all got to guess at what that means? TV racism. Give it again. And the jury affected by TV racism, Law and Order. I don't think they mean the TV show. I think maybe they mean the racism, get tough on crime type thing. Petrified by crime and unimpressed with Lucille as a reasonable citizen, convicted her, and I was the one who had to tell her that she was facing 15 years in prison, while we both silently wondered what would happen to the 4 teenage children she had raised almost single-handedly. I will stop there. Again, this is just one page. It is a rather lengthy report. Women in Prison, How We Are. And this is from April 1978. Net Jonestown, E. Anyway, forward to November. Anyway, I will just say I think that is so impressive. Like, she is so far ahead of her time, and so many of the issues that she is talking about, they're talking about right now. Things we've talked about before. First time, last time. Mental health and racism, jury selection, lots of things that they still are talking about now, because we are still in a system of white supremacy. Any hoodles, we'll get to folks who dialed in, see if they have thoughts, observations on the first chunk of the reading, get in a few of the emails as well. Now, folks did the same thing last week. They waited until it was almost time for the second audio segment. Then they put their hands up, and we had to wait till audio segment 2 for people to share. Hopefully they will not wait. I'll get in one email as folks are lollygagging or whatever. Email number 1. Greetings, Gus, listeners, callers. I read an article in which New York City Police Commissioner Donald F. Cawley stated that there were about 100 members of the BLA and 25 to 40 were in the New York area. On what basis did he come up with these numbers? Say it 15 times. That's so specific, like both ways. So, okay, how did you come up with this 100? Names, dates, source, all of that. And then, same thing. How did you, 25 to 40? That's kind of vague. Which is it? 25, 40, 35? Which is it? Same names, dates. So we got Assata. Scratch that off. So you got 24 more? You got 39 more? Who? That and that's the same thing as right now. Who's in Black Lives Matter? Any niggra? Who's in Antifa? Really? Any niggra? We've heard this one before. Who's in the Black Panther Party? Any niggra? Who's in the ANC? Any niggra? Who's in the Mau Mau? Any niggra? $25 to $40 in New York, whatever. No details given in the article. I'm very suspicious about the veracity of these numbers. See 9 allegedly in Black Army indicted. Here, Morris Kaplan, New York Times, August 24, 1973, year of the Jersey shootout and what have you. That's when they can just make black identity extremists. We just make it up as we go. Chapter 10. We could have added documentation on television and radio coverage, but we didn't have the money. Non-white victims lack of resources to defend themselves in the U.S. jurisprudence system is by design. That's another reason white people were so furious about O.J. Simpson. Like, oh my gosh, this nigger does have at least a few coins, not as much money as white people, but at least a few coins where he can go get a Johnny Cochran, an F. Lee Bailey. And they do have the resources. Johnny Cochran, F. Lee Bailey had money before they came to the O.J. Simpson saga. Remember F. Lee Bailey, he told us before he passed away, we used my helicopter. I don't think Evelyn Williams, at least we haven't been told about it, I don't think she owned a helicopter. Go fly over the Jersey Turnpike, collect evidence, track the route, all the rest of it, and gather evidence. I haven't heard that type of wealth, and she just became a lawyer. F. Lee Bailey. F. Lee Bailey was practicing law during the period that we're reading, early 70s, right? Boston Strangler and all those other cases, decades before he got the OJ. Experienced, veteran white man, F. Lee Bailey. Let's see. 2. The October 9, we are October hot all the way to the end. October 9, 1973, police security, the most massive in history of New Jersey. Middlesex County Jail entombed in the basement. 24-hour neon lights, armed occupation of New Brunswick, Assata and Sundiata, handcuffed in leg irons, and again, all this, and she still escaped. For reals, many people have talked about the incompetence of enforcement officials. This would have to be another. Like you say, this is the most white person hating niggra and cop killing niggra and the soul of the black identity extremists and the forerunner of Antifa, all of that, and you still let her escape? What kind of lames are you all? Let's see. New Jersey federal court judge conducts voir dire. I was a little upset, but I mean, it is AI. Is AI supposed to be able to read Latin? I guess they can work on that for the next year or so. It's voir dire. Say it correctly, voir dire. They said it correctly in Wisconsin. I was there in person, live front row for voir dire. Federal court. The judge has sole discretion to remove a juror for cause. This seems very incorrect. Never heard of this before. The defendant's lawyer should be able to ask questions directly. Hey, I guess that I have not been to federal court. That's why I wanted to go to Buffalo. Have not seen a federal court procedure. But wow, that is a lot of discretion for the judge to just, nah, you're out of here. You're racist, reverse racist, whatever. Get out of here. And hey, you already know, since they didn't have very many black attorneys, you know, ain't no black judges at this time period. 4. Juror neighborhood is all white. He would not have a black person living next to him. Neither would I. Blacks move into certain neighborhoods to break it up. If she's black, she's guilty. Not all white people are racist. And that's how it's written. Hey, I guess they said that's just one juror now. Don't be generalizing to think that all white people think automatically, O.J. Black, guilty. Bad example. Don't be thinking all white people say, hey, I don't want to live next to no nigger. Scratch that one. Bad example. Still, they didn't say that every juror thought this way. So, even though I guess eventually they did have to move to another county because they said, dang, it's going to be hard for us to find some jurors that's not racist and don't think this Assata chick did it already. Dang. Well, anyway, not all white people's racist. That's what they tell me. Let's see. 5. Robert Buckout, professor of psychology, Brooklyn College. 76% of voters questioned believed Assata and Sundiata were guilty. Suspected racist Dr. Buckout provided expert testimony, usually for defendants, because he was considered an expert regarding the unreliability of eyewitness testimony, which we also know from Pick the Case. Anthony Broadwater, pick your case. O.J. Simpson, pick your case. Lots of them to choose from, especially if you got a white person saying that, oh yeah, I seen Leroy and he did it. I seen him with my own peepers, and I saw OJ do it too. Definitely want to ask a billion questions and still be, I don't know. Let's see. Chapter, and I guess that might even go back, that 76%, what she phrased, because I said, I don't know what that means. TV racism, it probably cannot be overstated for this time period. Like in the newspapers, they talked about, they had Joanne Chesimard, aka Assata Shakur. They had her picture plastered all in the papers and magazines, and oh my God, she robbed the bank and killed the cop, and oh, look at that afro and all that. Man, you get white people been looking at that and looking at that and seeing that and seeing that, and then they put it on TV and talking about this, and oh, she killed a white man. Man, you guilty. I ain't got to see that. You guilty. You did it. You did. Really? Same thing with OJ. You put him on TV and darken him up good like we talked about. Oh, it's a shame what he did to Nicole. Oh, he guilty. He did it. How you know he did it? Niggas say he black. OJ say he ain't black. That nigger's black and he's guilty. Wait. We miss you, Juice. Let's see. Chapter 11. Louis Chesimard, ex-husband, college graduate, honorably discharged from the Air Force, veteran, remarried, one child, no criminal record, testified, forced him to obtain one of the vans used in the alleged robbery, unknowing and unwilling participant. It's hard for me to come to any other conclusion than he was threatened by enforcement officials. It would be so easy to do. And in fact, you already heard some of that in the book. Now, do you want to do the 20 years, or do you want to play the game, cut a deal, testify against that nigger woman who probably is a no-count cop killing, hating white? You don't hang with that type of coon anyway. Yeah, so you cut a deal. You testify with us. You let her do the 20 years, maybe 50 years, and you can go home, talk to your family. Or you can be opposite, that power to the people, and you can do 20 years. Make a decision, Leroy. Lewis. Easy peasy. You see that today. So, yeah, it would be, and hey, it could be a whole lot of different things. You want to do the 20 years, or we heard some torture in this book. I thought maybe they went and got them, what they said last week, they had the Germans on the police force, and Sig Heil, Lewis. Sig Heil. Hey, you see that plastic body bag? What we heard from Assata? Hey, we got one for you too. Make a decision. Lots of ways that they can do it. Real easy. 2. Young white panel of lawyers, small in group, a cadre shared an obsession with BLA cases. Same judges repeatedly assigned from the random selection wheel. I wonder if they had like a for real, like Wheel of Fortune type thing, and you spin it and it's supposed to select a judge. Are you serious? And then they're going to say, hey, this is justice. This is the way we do it. What? And then you spin the wheel and you still keep getting the same judges. They got a rigged wheel of justice? What's going on? Anyway, listener, right, he said, Voltron effect with all this. You get the same. And for real, I thought with that group of small lawyers, that was probably COINTELPRO as well. In fact, we might pay for them to go to law school and get really fancy degrees. Go get, Ivy League, Cornell, Harvard, that sort of thing. And then come back, take all the nigger cases. Any of them you get, Black Panthers, BLA, take all the cases. And we've heard about this before. Johnny Cochran told us about this, not in the O.J. Simpson case, although it could have applied there too, I suspect, but in the Geronimo Pratt case, he will be mentioned this week, that, dang, I think, and that's the same time period, so same organization too, But he said these folks then spying on our team, which is illegal. Lots of different ways doing it. Why would I think, yeah, they would be above that? When in fact, it would line right up to have this group of white attorneys, and they just go get all the cases, act like they are friends of the day. Hey, not all white people are racist. We support you. We're with the Panthers. We stand with George Jackson. Oh, yeah. We with Angela Davis. Oh, yeah. We with you. Right on. Power to the people. And they just, now, we got all kinds of, we make the court strategy for you. We pass along all the notes. You trust us. We get to pass on even more information. Send us some more. You got any of your nigger friends who locked up need legal counsel? Who are they? Write the names down. Where are they? Let's see. 3. Gagliardi threatened to have the defendants gagged, bound, and shackled if they continued their outbursts. The judge has an award given annually named after him. He lived to the age of 80, which is kind of low for race soldiers. His brother also became a judge. Nepotism. His father immigrated from Italy to the U.S. at age 12 in 1899 and eventually became a lawyer. Well, there you go. You pull yourself up, bootstraps and all that. Having black people gagged, bound, and shackled in court was very common during this time period. They have artistic drawings of Bobby Seale. Exact same thing happened. They didn't just threaten; they did it to him. But the same thing, though, of having all these sham cases. Maybe he had some of these white lawyers too. They take you in. He says something. They call you making an outburst, nigger, quiet, and they wrap some sort of fabric around your mouth so you can't talk and shackle you to the chair and shackle your legs so you have to be quiet. I think in some of these instances, Bobby Seale continued to, I guess, mumble or rattle his chains, whatever you could do from that restrained position. So they just wheeled him on out of the court, strapped to the chair and everything. This was done a lot. I don't know if Mike Swango, Jeff Dahmer, I don't know if they got that sort of treatment, if this happened to other white people, but this was very common for niggers in the 70s. 4. Jury deadlocked. One black juror held out. We have read about another lone black juror holding out in the book club, Miss Anna B. Hightower in Abraham Bolden's The Echo from Dealey Plaza. Just this year. Another example how it's so easy to get black people, because we read about that too. They get other black, oh yeah, Bolden, he was a snitch and stealing money, and oh yeah, he's the worst nigger since Fred Hampton and those Panthers. Same time period too. 5. Relieved of my responsibility to represent her, Florence Kennedy, the well-known black feminist attorney, to be co-counsel with Assata. Verdict of acquittal. Bronx bank robbery. Kennedy, 1916 to 2000. Her father fended off the family from a KKK with a shotgun. What? When she was a child growing up in Kansas City, Missouri. What? I've been to KC. What? Shout to Roger Golubsky. What? Even though that's Kansas City, Kansas, it's right. Same thing basically. What? When she was rejected from the Columbia Law School in 1949, she threatened to sue and was admitted. What? Oh, I just mentioned Ivy League, see? She was married briefly in a tragic arrangement in 1957. She also represented H. Rap Brown. El Amin, name change there as well. El Amin, I think. Black Panthers and the estates of musician Billie Holiday, Charlie Parker, in order to obtain music royalties. I think Charlie Parker went to one of the schools that's struggling to stay open in Missouri. I could be in error about that. Billie Holiday with her Missouri connections as well. In addition to practicing law, she acted in movies and television. She was unmistakable, wearing a cowboy hat, pants, and pink sunglasses. She is credited with being an important activist in what is referred to as second wave feminism, and is a founding member of the National Organization of Women. Well, I will have to make sure I ask, because generally university environments, they are saturated in white feminist studies, so I will investigate to see, are people familiar with Florence Kennedy and her contributions to counter racism? Do they read about what? Her family had to fight off the Klan? What? Isn't that something? We've read half this book. Wilmington Purge of 1898 was omitted, but we have still heard countless stories about black people being terrorized, castrated, sodomized, painted white, and ran out of town. Or at least the attempt was made to get you out of there. Dang. System of White Supremacy Racism. From New Jersey, Kansas, North Carolina, doesn't matter. System of White Supremacy. I'll stop there. We'll pick up the rest as we proceed. Let's see. Email untiljustice@gmail.com. Folks who dialed in, *61. Let's see. Lauren should be with us. Nab other hands as we proceed.
Yes, sir. Can I be heard?
Yes, ma'am.
Okay. Evening, Gus. Evening, everyone. Thank you for allowing me to speak. I had a couple of things from last week because I wasn't here. Is it okay if I go back and make a couple of comments about that?
Let's hear it.
Okay. So last week when Assata, Evelyn Williams takes the recorder and Assata makes the recording. And during the recording, she says, "Black revolutionaries do not drip from the moon. We are created by our conditions, shaped by our oppression. We are being manufactured in droves in the ghetto streets, places like Attica, San Quentin, Bedford Hills, Leavenworth, and Sing Sing. They are turning out thousands of us." That made me think about Mr. Fuller. He wrote, "White supremacy breeds opposition to white supremacy. Non-justice breeds opposition to non-justice. Incorrectness breeds opposition to incorrectness. That is the law of compensation." That was on page 18 of the original code book, and, that's what I thought of when I read that. After that recording is released and it gets played on the radio, the white man in court, Hamlin, the prosecutor, he says, let me see. In the affidavit, he stated that I acted to create sympathy for the accused and to inflame the public by her statements in the media and in the newspapers in order to deprive the state of a fair trial. And then Detective Harold Bott submitted an affidavit claiming that Assata and I had met to prepare a political and revolutionary speech, a call to arms, a little short of a call to treason, while maintaining her legal and moral innocence. The defendant, in inflammatory terms, accused the authorities, charging them with murder and kidnapping. The broadcast was designed to affect the thinking of potential jurors and was obviously calculated to destroy the right of the state to a fair trial. And first, I think we should pay attention to the use of the term fair trial and just all the ways that fair is used in its text, because it was a lot last week and this week. And also, white people are accusing of Assata of doing exactly what they've been doing for the last 2 years with, all the news reports, the radio reports, the newspaper, affecting the thinking of potential jurors and calculating moves to destroy the so-called rights of Assata. That was just interesting to me. Let me see. Oh, I don't know. I'm not sure if it was discussed, but those Baginski tapes, when they're asking the question, and Kelly asked, if you recall, approximately what time was it when Trooper Harper arrived at the station announcing he had been shot? And he said, to the best of my recollection, it was around 12:58 to 1 a.m. So apparently 1 hour elapsed from the time that Harper arrived at the station and announced that he had been shot and the time that you were first aware that Forrester was in difficulty. Would that be correct? And Baginski says it's about the right time. And I just, why wouldn't Harper tell them that Forrester had been shot? Like, it seems like that would be the second sentence out of his mouth. Like, you run in there, I've been shot, Forrester's been shot, I ran away, plus whatever additional details you're going to give them. And even, like, I don't know, I'm not the police or anything or law enforcement. When you watch TV, when you watch movies, somebody gets shot on the radio transmission. That's like the first thing they say. They get on their little walkie-talkie or whatever their little thing is called, and then they say, officer down. I mean, that's like one of the first things that they get out because it's super important. If that was true, it just seems like he would have told somebody that a white man had been killed out there if that was the actual case. But Baginski also, like right after that, maybe like two transmissions or questions, he said there was no mention made of Trooper Forrester by Trooper Harper at the time of his arrival. I thought that was really interesting, and I didn't remember it being discussed last week. Let me see. During Sundiata's trial and later in Assata's trial, he said he assumed that Assata, this is the law enforcement officer who was testifying, he assumed that Assata had fired at him from the car because just before he heard a shot and after he ordered her to put her hands in sight, she had made a gritting facial expression, bared her teeth, and emitted a growl. His remarks, I thought, seemed like something human beings, white people, perception of how animals, particularly Black Panthers, prepare themselves for attack. And you know, I was thinking to myself that, yeah, white people do think of this as animals. Below people made me think of that German term, Untermensch, Underman. Also, it made me think of the law enforcement officers speaking the German Nazi words, the slogans, while Assata was still in the hospital. I just thought of all the time and effort she spent with those tapes. And, you know, she said she made what she called a care package with, you know, the photocopied transcriptions of the Magnusink and the Baginski tapes, the Station Bible. Just, there's so much time and energy she dedicated to this. And also I should say that, like when Assata got arrested, she quit her job at NYU that day. I mean, there was almost zero hesitation. And, you know, this lady, she just has, it's obvious to me that she has such a high level of care for Assata Shakur. And, you know, I think I said it the week before last, but I think Miss Evelyn Williams, very admirable person. Okay, this week, Chapter 10, again with the use of the word fair. Because one of the first things she did, she said, we cited parallel circumstances that had existed in Shepard v. Maxwell, Irvin v. Dowd, and Estes v. Texas, in the latter of which the Supreme Court of the United States had said the court has insisted that no one be punished for a crime without a charge fairly made and fairly tried in a public tribunal free of prejudice, passion, and excitement and tyrannical power. Also, she made those motions for the trial to be dismissed. Jurowski denied both motions, opining in relation to the first that jurors are chosen by computer from registered voter lists and suggesting that if there were fewer blacks on the panel, the reason lay not in the very fair selection process, but in the lethargy of the black citizenry who did not bother to register. So, you know, white people are not practicing racism. Black people are just lazy. Got it. Let me see. I also noted the voir dire mispronunciation. I didn't know what that meant. When that juror, when he said blacks make it a point to move into a certain neighborhood to break it up, what does that mean? They're going to tear up the neighborhood, make it raggedy? Is that how you took that, guys?
Well, they do have a racist term called block busting. That was what I thought of, where white people, a white realtor generally, will bring in one black person, one black family, whatever, and sell them a house. And then as soon as they do that, oh my God, the nigger's going to break up the building, and all the white people move. And the white people frequently, even though they know a white person had to sell them this house, the white owners had to sell it to them, the white realtor and all that, they just blame the nigger. That's what I thought of. He might be talking about that they break it up, block busting, but this is a term. This is not something Gus made up. This is like redlining and all that, block busting, but this is something white people do to break up white neighborhoods by bringing in a few niggers and all the white people. So white flight.
Okay. Thank you for that. I have to admit, like, there was so much going on, I got confused. Like, there was so many, like, she has the first indictment where she's on the New Jersey Turnpike, and then there's just so many indictments. They give a date, they charge this person with this, also Assata. They charge this person with this, also Assata. And it happened, like, I don't know, 5-7 times, maybe more. And I was just a little discombobulated. Like, I wasn't understanding what I was reading. I just had difficulty actually, ascertaining that, like, they're charging her with all of these different crimes in such rapid succession. Let me see. I noted that it said the politically sophisticated city of Newark was in Essex County. Its voters had elected Imamu Amari Baraka Taimu, I'm not sure how to say that one, and Hope Jackson as its assembly representatives. So I just wondered, politically sophisticated, is that what you call it when you vote for non-white people? Because I wasn't really familiar with that phrase. Let me see. More use of the term fair. I took note of all the times that she got indicted for things. There was a lot. And she was, Miss Evelyn Williams, she said she was representing Assata on all of the cases for which she had been indicted, appearing with her at arraignments and filing the usual pretrial motions, but the multiplicity of indictments disturbed me less than the growing number of alleged BLA members being arrested, and I was haunted by the prospect that one or all of them would plead guilty and falsely testify against her in exchange for a light sentence or other consideration. The September 1st, 1972 Bronx bank robbery trial proved that my apprehensions were well-founded. And it just, again, Miss Williams seems like admirable lady, excellent lawyer, pays attention to detail. I just think this would be too much for any one lawyer to handle all at once. And Assata probably, didn't have money to hire a different lawyer for all of these different trials. They, charge you with 5, 10, 20 different crimes. Who has money for that? I mean, besides a white person or OJ, I don't know, but that wasn't 20 different crimes. That was just murder of, well, I guess 2 white people. Let me see. The stuff that her ex-husband said in the trial that he went to, she always carries a gun and wears disguises, and even a person who knew her well could pass her in the street without recognizing her, and that she had forced him to obtain one of the vans allegedly used in a robbery. I mean, I don't know. The setup, it was so intense. It was a lot. That David, what's his name, David Bloom? The lawyer's last name was Bloom. And Miss Williams was suspicious of him, but Assata wasn't. And, I think she should have been. Also, on page 115, she was talking about Judge Gagliardi, and this is in court, and she's talking about him, and Assata says he was like a 2-year-old baby, so unintelligent as to force a lawyer and a client to go to trial when they were not prepared, charging that he was bought and paid for by big business and had no concern for justice or black people or for poor people or for any defendants except Mitchell and Stans. Finally, to avoid the brutality of their marshals, she would rise as they approached, saying in her usual quiet voice, "I will remove myself," and then stalk regally from the courtroom, trailed by Kamal and the marshals. I don't think it was wise to do that. I mean, she's probably going to prison. Well, she's definitely going to prison. We know that, right? But, and also, I just don't think we should keep equating white people practicing racism with them being unintelligent. That's an idea that's just inaccurate, and it seems super common, but I'm still pointing it out. And then in the testimony, like, there was no time to prepare, and like, I was super confused. She said, with no other recourse available, both Assata and Kamal agreed that the only role the lawyers could take was to remain mute throughout the trial and make no opening or closing statements, to cross-examine no witness, and to participate in no way in the trial, hoping to use Gagliardi's decision to obtain a reversal on appeal of the inevitable conviction. I'm not sure if I've ever heard anyone doing that before. It seemed like a poor idea, but it worked, because it said the government rested its case after one day of testimony, and within hours after jury deliberations began, the jury returned announcing they were hopelessly deadlocked. And it ended up being, I think it ended up being a mistrial, or correction. So we later learned that one black juror had held out for acquittal because the refusal of defense counsel to participate gave validity to Assata and Kamal's charges that they were being denied a fair trial. So I guess it worked, but wow. Just a little dangerous. And I think that's all I have for, no. There was the New York Times article about Assata Shakur and Miss Evelyn Williams, their courtroom decorum, and that made me think about, was Jonestown a CIA medical experiment? Like, the collaboration of the New York Times and the CIA were just super powerful white people, whatever you want to call it, not just the CIA, law enforcement, whatever. And that's all I have for this segment. Thank you for allowing me to speak.
Much obliged, Lauren. Same time period. I think I said that a few weeks ago. Same time period. I would bet all the money I have in the world, all 2 cents, Jim Jones, I bet he talked about Assata to those Negroes he killed. I would bet my life he talked about Assata to those Negroes he killed. Wouldn't even be that stunt. Might have pictures of him and Assata together. Like, I would not be. They got pictures of him and Huey Newton together. So, and Angela Davis, they were pen pals. So, I would not be surprised if he snuck over to catch one of those trials. Right on, black sister. We right out. Man. Anyway, the newspapers. That is a massive component of COINTELPRO. And just white supremacy racism. I had totally forgotten. White people have strategically weaponized newspapers against black people for the entire time that the so-called USA has existed. So that would be what, talking about 250 years? The entire time. I totally forgot. White people have written whole books about how important newspapers were to runaway slaves. Fugitive Slave Act and all of that. Frederick Douglass gets drapetomania. 12 Years a Slave. We read that one, remember? But old Harriet coming around here tiptoeing and, doing her devil work. They should dress up as Harriet Tubman for Halloween. How about that? Anyway. But tipping around doing her devil work with $20 bills, and you scratch out Andrew Jackson, put your face on him. Anyway, but you have a few niggers, they get away, You got to put it in the newspaper. You put in your description, dark, I had to whip him 15 times, chopped off a foot, blah, 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 whatever else, high yellow and all the rest of it. But newspapers, massive. You going to sell a niggra? Where do you go? You don't have Facebook? Newspapers, that they have been massively important in just different forms of media, because even though you don't have newspapers anymore, you still got New York Times, you still got BBC. So, but yeah, that is the racist weaponization of newspapers and all forms of media journalism in the depiction of black people was massively important during this time period. That the Black Panther Party, oh my God, Dr. King, even Minister Malcolm X talked about this, he is a devil and you hate white people. Ooh. Massively important. Same effect. They are masters. The blockbusting component we got, I guess, in terms of the being overwhelmed, she said it was so much that it confused her. That is the desired result. Totally overwhelm your ability to respond, to even just really overwhelm your brain computer. That is exactly the desired result. How can you, how many court cases can one person take on at one time? Really, and I mean, some of these are felonies, some of them, and you robbed a bank and killed a white, I mean, this is not a parking ticket or something. These are massive, some of these trials could last weeks, Even how many of these cases could one attorney, because Lauren was saying, man, Evelyn Williams is something, and I think this is more than she could handle. Is supposed to be more than anybody, the person being charged, any of them. And that's explicitly written in the COINTELPRO documents in terms of policy and procedure, what our aims are, what are we trying to do. And it says that overwhelm them totally, even if we're just making up specious, fabricated charges, and we know she didn't kill this white cop, or we know she didn't rob this bank, whatever. It'll waste a good month in court, maybe 3. We might get them confined for some of that time. We'll waste some of their money. They barely got 5 nickels anyway, and they'll have to pay something, even if it's just to get photocopies or whatever, and it'll severely disrupt their ability to make money. You're confined. Lots to our advantage, and time and energy. Just time and energy. You could be doing all kinds of things. Nope, you're stuck in a cell, fighting all kinds of goofy charges that you probably didn't even commit these crimes. We know you didn't commit these crimes, Geronimo Pratt, but you're still going to waste 6 months in court. And same for Evelyn Williams. You could be doing this, you could be doing that. Nope, you're going to waste 6 months in court for bogus crimes and get in conflict with your niece all over some racist, all over racism. And that's part of it too. They wrote that out too. We know we're going to get people divorced. We're going to break up families. Miss Williams in tears, can't get along with my niece who I adore. All by design. White people wrote this out in black and white. This is exactly what we want. Jameen Al-Amin, that is new name, H. Rap Brown, suffered, victim, same type of a thing. Any hoodles, let's see. And I think some of the other defendants, I think that strategy of we're not going to participate because this is a total sham. I think some of the other defendants from that time period did the same thing. Yes, it is risky, and I think sometimes it worked. And if you notice, lots of these charges, they were acquitted. Now, you can't celebrate, but it's just like, dang, we wasted all this time and energy. And it's not like when you get acquitted, they come and give you, my bad, we're going to compensate you for that, and you get extra lawyer fees, and I don't know, you get a get out of jail free card. So next time we come and charge you with a crime, like, oh no, you messed me over last time, get on out of it. It's not even like it works that way. Just, oh well, be glad you didn't get locked up. And don't be late for hearing tomorrow, because we got you for you tried to kill that white cop. We just go on down the list and keep going and keep going. And get that, Miss Williams said, I was afraid somebody gonna cop a plea. We already know that. That's part of the COINTELPRO activities. We talked about that with William O'Neill. In fact, William O'Neill is the black male, Judas and the Black Messiah. That movie, fictional depiction of the assassination of Fred Hampton, Mark Clark, Black Panthers in Chicago, 1969, December, if my memory is accurate. But William O'Neill, one of the things I disliked about that movie, it's fake, it's fake, it's fake. William O'Neill was like 18, 19 years old when he was brought in as an informant. They made him look like a grown, in quotes, black dude. He was really young when he was brought into all this, and he had a criminal record. It's super easy to manipulate some child whose brain computer is still developing, and they got what I said already today. You want to do the 20 years? You help us put Assata in prison for 20 years, or maybe kill her, whichever comes first. But you want to do the 20 years? All right then, shut up and we'll meet with you tomorrow. And hey, you do a good job, boy. You know, we might have something in it for you, which I'm told William O'Neill, he got like money. I think he even got a business. They compensated him. But, you know, hey, now, you're going to have to help us kill that Freddie. No count, you know, niggra's a gangster anyway. You know, we'll hook you up. Just help us out, William. And he did commit suicide. So, I mean, hey, I guess he felt some type of way about being victimized and used. We will get to audio segment 2. If you have additional thoughts, comments, write them down as we proceed. Evelyn Williams Inadmissible Evidence, audio segment 2, Katherine Massey Book Club.
Chapter 12. While the acquittal in the Bronx bank robbery trial did not receive the same attention the trial had, it was nevertheless widely reported. The day following the acquittal, when Assata was immediately convoyed back to Morristown to stand trial for the turnpike shootout, radio and television news reported a new indictment in headlines such as, Joanne and 4 black libs indicted in the shooting of C.O.W.S. Joan Carey, the Queen's Assistant District Attorney, had announced the indictment against Assata, Andrew Jackson, Avon White, and 2 other Army members still at large for the attempted murder of 2 policemen, Roy Polina and Michael O'Reilly, by shooting at them with submachine guns, sawed-off shotguns, and semi-automatic pistols on January 28, 1973, in St. Albans, Queens. This year-old charge, just translated into an indictment, was but another example of the conspiratorial efforts of law enforcement agents to extract indictments against Assata and to publicize them at crucial moments in her many legal battles. To them, the Bronx bank robbery acquittal was an insult, and the existing untried indictments were not enough to satisfy their thirst for conviction. More insurance was needed, and even if she was not to be convicted on this most recent charge, the manipulated negative impact on the Morristown jury still to be chosen was well calculated to succeed. The assault against alleged members of the BLA did not end with Assata. On the second day after the Bronx acquittal, Kamau was indicted and arraigned in Bronx Supreme Court for the attempted murder of 2 policemen, Joseph Lombardo and James Carey, on March 6, 1973, by firing 14 shots at them during a high-speed chase. Kamau was indicted with 2 unnamed other members of the BLA who escaped and who were still not identified. Also publicized in the newspapers alongside these articles was the beginning of the second trial in the New York Supreme Court of Deruba bin Wahad, a member of the Black Panther Party, for the attempted ambush murder of the 2 policemen driving in their patrol car on Riverside Drive in 1971. The first trial having ended in a hung jury on December 9, 1973. Deruba was convicted in the second trial and sentenced to life imprisonment. After 19 years of incarceration, including his time in prison before the trial, his conviction was reversed as a result of the heroic efforts of his attorneys, Elizabeth Fink and Robert J. Boyle, in January 1990. Documents they received through the Freedom of Information Act revealed the insidious and illegal withholding of favorable evidence during his trial, the intentional falsification of evidence, and the complicity of the government and the New York City Police Department in constructing his conviction to coincide with planned disruption against militant organizations and manufactured charges as specified in the FBI's COINTELPRO guidelines. The COINTELPRO offensive efficiently operated with the complicity of its primary media agents, the Daily News of New York and New Jersey. On January 7, 1974, the Daily News ran a feature story entitled "How the Cops Hunted the Last of the Black Libbers and Trotted Out the Well-Reported November 14, 1974, Ambush Slain by Police of Twyman Myers," detailing how he had been fingered by a reported BLM member, Joe Lee Jones, and followed it up with a feature story on January 8th entitled "The Black Lib Army's Strategy in Blood." On January 10th, 1974, the newspaper began a 5-part series called "Black Lib's Diary," describing the alleged surprise existence of the diary of Denise Oliver, Andrew Jackson's girlfriend, who had been arrested with him on June 8, 1973, and reproducing handwritten pages from the diary. The excerpts described the despair of living underground and revealed that Jackson was thinking of surrendering. The news prefaced the diary excerpts with the comment, "The arrest of Joanne Chesimard, sister love to the Black Liberation Army, had a severe psychological impact on the militant band." And quoted from Oliver's alleged diary, "Today it was Joanne who I never met, but I feel as if I know her, even though it has been knowledge gained through the half-baked lies and propaganda of the news media. And today it was Zaid. I never thought he would wind up a corpse in New Jersey on the turnpike. I suppose I assumed his existence would always be inevitable. But I was wrong. He dies and Joanne lives. Ironic when you consider that Zaid had a great tempt death. It was inevitable that Joanne would eventually be caught for her acts. But that is intellectual. And in the gut, a certain misplaced pride glows. A sister, a get-down sister, right or wrong, a she not a he, has become a martyr. Compounding the impact of this dredged up and revitalized old news were stories of 2 trials of alleged BLA members that began on January 8th. The New York Supreme Court trial of the BL5 Herman Bell, Anthony Bottom, Albert Nuh, Washington, and Francisco and Gabriel Torres, and the trial of Henry Brown, alleged BLM member, for the murders of policemen Foster and Laurie. Repeated in the news article about the latter was the death of Ronald Carter, killed in a gun battle with police in St. Louis in February 1972 and accused, along with Brown, of the police murders. Given prominence in the news stories were Brown's 2 escape attempts, the first from the Brooklyn House of Detention in April 1972 and the second from Kings County Hospital in October 1973. If any residual anger remained from my confrontation with Assata during the Bronx bank robbery trial, it entirely dissipated in the face of this enveloping, artificially created negativity. The day after Assata's removal to Morristown, I met with her for an hour alone in a small room next to the courtroom, and we talked without strangeness or bitterness. As always, we needed no protracted explanations or excuses. Slimmer and paler than when I had last seen her, she simply said, "Auntie, I'm sorry. Will you please be my lawyer?" And I said, "Of course I will." She was not triumphant about the acquittal, having already dismissed it, and determinedly was ready for this trial and the next one and the next one and the one after that. As the jury selection process began, I was astonished by the dramatic changes that had occurred in both Judge Bachman and Ray Brown during the previous 2 months. The camaraderie and respect they had demonstrated for each other in the early days of the trial in Middlesex County, Bachman, an experienced jurist, and Ray, an experienced practitioner who had appeared before him many times in his representation of major crime figures in New Jersey, had changed. Bachman was no longer impartial, no longer reasonable, no longer willing to apply U.S. Supreme Court decisions to the particularities of this case. Responding to citizens' anger over the increased cost of the trial to taxpayers because of the expensive security measures the county felt it had to install, to delays in the previous trial, to people's resentment over the bank robbery acquittal, to the cry for the conviction of these obviously guilty animals who did not deserve the civilized privilege of a trial, and to the public's need for quick and merciless justice. Bachman reversed many positions he had previously taken. Both Sundiata and Assata were Muslims. In the earlier part of the trial, no sessions had been held on Fridays, their day of worship, but Bachman rescinded this restriction and the trial continued 6 days a week in the rush to completion. During the first trial, he had adjourned for the 2 or so days we needed to file motions for a change of venue from Middlesex County, but this time he refused when we filed the motion to move the trial from Morris County. Whereas before he had patiently listened to our arguments, now he made his decisions before we were finished and, once he had made them, stormed from the courtroom, leaving us talking to an empty bench. His face reddened easily, and a stern, frowning countenance replaced the easy amiability I had been so familiar with. And now, masked within Ray's consciousness was a rage at the inequities in the statutory standards for selecting jurors, which effectively excluded blacks from either grand juries or petty juries, documented in the Buckhout and Payne surveys. In his vast experience, it was the one aspect of the criminal justice system he had never challenged, and it was as though he was determined to compensate for all those years when he had assumed its fairness. He engineered the attack against the process, insisted on presenting all the oral arguments himself, and pressed for a change of venue and appealed to the federal court when another motion for a change of venue was denied. Energized by the research that had been done, he skirted on the fringes of repeated contempt citations in his zeal. And that transformation, I'm sure, was permanent. Each day of jury selection brought a new meaning to the words tedium, frustration, and helplessness. The voir dire droned on endlessly. Questions. Objections for obvious bias. Requests for additional questions. Motions denied. Another juror. The same questions. The same objections. The same denials for additional questions. The monotony was interrupted by new motions for a change of venue after the prosecutor used his peremptory challenge to excuse one of the 2 black jurors, 125 on the panel, and when Bachman refused to increase our peremptory challenges, which had been reduced from 10 each for Assata and Sundiata to 5 each when the trial had moved to Morris County. When we discovered that several copies of New York Police Commissioner Robert Daley's recently published book Target Blue, from which excerpts had been published in New York Magazine, were prominently displayed in the jury room, we moved for a dismissal of that panel and included the incident in our motion for a change of venue to Essex County. Bachman refused to dismiss the panel or to move the trial and, contrary to his decision in the first trial, did not even excuse the panel for taint but let go only the 2 jurors who admitted having read the book. When discovered, each book had been turned to a page in which Daley traced the movement of members of the BLA across the country, describing the way in which black extremists managed to get from Harlem to Algiers with such ease. The leaders of this extremist wing were apparently more Dhoruba bin Wahad, Andrew Jackson, and Joanne Chesimard. They were the contacts in New York for wanted blacks from any part of the country. Joanne would make up phony identifications, and from Harlem, fleeing blacks would go to Canada, then to Paris, and finally Algiers. In the streets surrounding the courthouse, the Ku Klux Klan, banners prominently waving, circled the building, chanting, "White power and death to the BLA." They clashed with Assata's and Sundiata's supporters and provided an ominous backdrop for the sham going on inside the courtroom. Then suddenly, everything was interrupted by Assata's unexpected illness, which would dramatically alter the direction of the defense. Ray obtained the incomparable services of Dr. E. Wyman Garrett, a board-certified obstetrician and gynecologist from Newark who was licensed to practice in both New Jersey and New York and whom Bachman permitted to examine Assata. Dr. Garrett confirmed what she had whispered to us that she had suspected: she was pregnant with Kamau's child. As I listened to Sundiata's gentle teasing, I was absorbing the impact of the news. I calculated the time remaining before she gave birth and the barbaric conditions of her special incarceration, which there was no reason to believe would change. The administration of prenatal care by despising prison doctors was unthinkable, but I wondered if I would be successful in obtaining a private obstetrician. I wondered about the baby's survival in the airless, sunless dungeon of Middlesex County Jail. Neither her mother nor I condemned Assata, and we quickly agreed to share the child's upbringing should she be convicted. We had long since adjusted to the fact that Assata was a product of the 60s, acting independently of the sexual restrictions that had so governed our lives and substituting a new morality. She was a fierce believer in women's rights, including the right to abortion, although she rejected that choice for herself. It was also understandable, in light of her solitary confinement for more than 8 months without even conversational camaraderie, that the long days in the holding pen behind the Southern District courtroom with Kamau, a person she respected and trusted, would have provided the opportunity for comforting embraces to merge into intimacy. After allowing Assata a short stay in Roosevelt Hospital, Bachman decided that he would not risk further delays in the trial for anticipated morning sickness or other discomforts that can accompany pregnancy, and he severed her trial from Sundiatis. Assata was returned to the basement of the Middlesex County Jail to await the birth of her child in horrendous, inhumane conditions. The National Conference of Black Lawyers and Prisoners' Rights Organized Defense (PROD) filed a complaint in the U.S. District Court for New Jersey protesting the prison conditions and charging that Assata's constitutional rights as a pretrial detainee with no prior convictions were being violated. Plaintiff is kept in 24-hour solitary confinement, with no opportunity for fresh air, recreation, physical exercise, movies, TV, social contacts, and without minimum privacy in the exercise of her religious and personal needs. Plaintiff is kept in 24-hour solitary confinement with no opportunity for fresh air, recreation, physical exercise, movies, TV, social contacts, and without minimum privacy in the exercise of her religious and personal needs. The basement cell in which plaintiff is confined alone for 24 hours a day has no natural light and poor ventilation. Utility pipes are exposed in the low ceiling and the floors are cement and damp. The cell is infested with ants and centipedes. Additionally, Assata's diet was so nutritionally deficient even cheese, eggs, and vitamins were withheld that it would not sustain an adult woman, much less a pregnant one. Dr. Marcella Katz, a nationally renowned nutritionist associated with the Institute of Human Nutrition at Columbia University, attached an affidavit to the complaint, setting forth her analysis of dietary deficiency and spelling out the danger to both Assata and her unborn child. During the hearings on the complaint held in the federal court, Dr. Michael Oliver Smith, a New York psychiatrist, testified about the effects of sensory deprivation resulting from the lack of natural light, lack of fresh air, lack of exercise, lack of recreational material, severe lack of human contact, and lack of spiritual contacts. Noting that a great number of scientific studies completed in the past decade clearly have demonstrated that prolonged sensory deprivation regularly causes psychotic or schizophrenic breakdown. He concluded that if Assata had not been such a strong and independent-minded person, it is very likely that she would have had a psychotic breakdown well before this time. Dr. Smith was the only person except prison guards to see the inside of Assata's cell. He testified, "I have never seen a prison cell that was shrouded and hidden from the world in any way comparable to Miss Chesimard's. The effect of the lack of natural light, lack of fresh air, adverse temperature changes, water leaks, and vermin is to create a consistently degrading and debilitating environment out of all proportion to conditions in other parts of the Middlesex County Jail or any other prison facility that I have observed. The circumstances of Assata's confinement were a precursor to those in the Women's High Security Unit at the Federal Prison in Lexington, Kentucky, a special small group isolation facility set up in October 1986 for political women and designed specifically to destroy Alejandrina Torres, Susan Rosenberg, and Sylvia Berardini, who were convicted of a variety of alleged subversive acts against the government. Amnesty International revealed in a 1988 report that led to a court-ordered closing of the unit. This program, the High Security Unit, set up a hierarchy of objectives. The first of these is to reduce prisoners to the state of submission essential for their ideological conversion. That failing, the next objective is to reduce them to a state of psychological incompetence sufficient to neutralize them as efficient, self-directing antagonists. That failing, the only alternative is to destroy them, preferably by making them desperate enough to destroy themselves. The report concluded that these conditions were the same as the dead wings isolation units and white cells painted in high-gloss white and illuminated around the clock with fluorescent lights that existed in Germany's Stammheim high-security prison to accomplish the same goals. Stuart Gracian, in a report called A Review and Delineation of a Clinical Syndrome, traced the development of psychological syndromes resulting from isolation that have been documented during the 19th and 20th centuries in Europe and in Korea for U.S. prisoners of war. And it must be added, the conditions of incarceration suffered by Sundiata after his conviction and by Sekou Odinga, Geronimo Pratt, Mutulu Shakur, and other political prisoners were no different. The federal court dismissed the complaint, and while the appeal was pending, on May 10, 1974, New Jersey abruptly complied with one of the several warrants filed against Assata by the state of New York, and she was transferred to the Women's House of Detention on Rikers Island in Queens. But victory is measured not only by legal decisions. Assata was at last out of the dungeon and into the general population with other inmates. She was able to have visitors, fresh air, and nutrition that met the minimum requirements necessary to sustain her. Following its well-established mode of operation, once she was in New York, the government quickly held arraignments, pregnancy or no pregnancy. On May 11th, Assata was arraigned before the Queens County Supreme Court for the January 23, 1973, attempted ambush murder of policemen Polina and O'Reilly. On May 29th, she was arraigned in Kings County Supreme Court for the drug dealer murder, and on May 30th, she was arraigned in the same court for kidnapping a drug dealer. Dr. Ernie Garrett wanted to continue as Assata's obstetrician, and the motion I filed in Queens Supreme Court to allow him to do so was granted. He had the tall, broad-shouldered, graceful body of a football pass receiver and was as jaunty in appearance as he was casual in manner. He wore the latest fashion in clothes and drove the newest model of custom-made Lincoln Continental sedan, but his large, soft, gentle-looking hands were the truest indicator of his personality. As soon as the court gave its permission, he visited Assata at Rikers Island frequently until the day she was moved to Elmhurst Hospital to give birth. He charged the family no fee, not even out-of-pocket expenses. Technically, he was under the supervision of the Montefiore Hospital doctors who were hired through city contract to provide medical services to the prison and was required to accept their presence during each of his visits. Although he chafed at the insult to his credentials, his dedication to Assata and his need to visit her regularly, supervise her condition, and watch the progress of her pregnancy were more important. Despite the many times he made the long trip to Rikers from Newark only to be told that the doctor scheduled to be present with him was unable to be there, requiring him to make another appointment, his calm demeanor and quiet self-assurance never changed, to the chagrin of the hospital and prison administrators. As they persisted in these petty and unprofessional inconveniences in the face of his constant equanimity, they could not know that he recognized their attempted humiliation as but one of the many ways in which white professionals frequently try to denigrate the achievements of black professionals, and therefore, they were unaware of the ease with which he deflected their intended impact on his performance. Ernie's visits to Assata became more frequent as her delivery neared, and when he told prison officials that birth was imminent, he was forced to pace impatiently until another Montefiore doctor arrived at the prison to confirm his diagnosis. Then he had to wait in the parking lot for the police convoy to arrive at the prison and follow the screeching caravan to Elmhurst Hospital in Queens. There, however, he was told by hospital officials that the court order permitting him to care for Assata during her pregnancy did not extend to delivering her child, and they would not afford him hospital privileges, although it was within their authority to do so. I had visited Assata almost daily in those expectant days, always on the days Ernie had scheduled to see her because of the prison's constant tactics to prevent his medical examination and prescribed treatments. On the day of her labor and delivery, Doris was visiting her as well. Doris's car was parked on the mainland side of the bridge connecting it to Rikers Island, while Ernie was parked in one of the island's reserved parking spaces set aside for prison officials. Doris and I rushed to the bus that took visitors from the island to the mainland and waited in the parking lot until the convoy passed, watching Ernie's pursuit with amusement. When we got to the hospital at about 4:00 p.m., I was stunned to learn of the hospital's decision not to allow Ernie hospital privileges. It was too late to try to obtain another court order, and Assata, her large afro braided, sitting cross-legged on the hospital cot, arms planted protectively across her stomach, refused to permit any Elmhurst hospital doctor to touch her and vowed that if Dr. Garrett could not deliver her baby, she would deliver the baby herself. It was a standoff of global proportions and one that was fraught with potentially tragic consequences. Ernie refused to leave the hospital and sat in the lounge consulting with me as I attempted to negotiate the stalemate. The Elmhurst hospital doctors flitted in and out of Assata's room in increasing numbers as the night wore on and as birth became more imminent. Their attitude turned from contemptuous dismissal of the mere suggestion that they would allow a private doctor to deliver a prisoner's child to their stubborn insistence that their policy and decision were correct, to their nervous realization that they might be forced to relent in the face of Assata's insistence that they not touch her. Finally, they crumbled into unadulterated panic. In the meantime, hundreds of Assata's friends and supporters had filled the streets in front of the hospital, loudly demanding that Dr. Garrett be allowed to deliver the baby, and the first floor corridor was crowded with television cameras. It was only because of all of these factors combined that the hospital capitulated and permitted Ernie to deliver the baby. The officials and I, after discussion with both Ernie and Assata, fashioned an agreement among Assata, Ernie, and the hospital, relieving the hospital of any responsibility that might result from the delivery performed by Ernie and permitting him to continue to treat Assata during her postpartum stay at the hospital. At about 4:00 a.m. on September 11, 1974, Ernie delivered a beautiful baby girl, Kakuya Amala Olugbala Shakur, whose birth I announced to the exulting crowd. For the next 2 weeks, Assata was permitted to remain at the hospital where she nursed Kakuya, the most pleasant memory she was to have for several months thereafter. On September 25th, the hospital released Kakuya to Doris's custody, and Assata was returned to prison on Rikers Island.
Matulu Shakur. Difficult, I guess. The AI narrators, they still are learning Latin, and then any of those, I guess, special, peculiar Negro handles. Assata doesn't do too well. It really butchered Matulu Shakur, victim of white supremacy. Context of White Supremacy, Katherine Massey Book Club. So we'll pause until next Friday. We will resume chapter 13. Number to dial 720-716-7300. The code 564943 pound. Press star 61 if you would like to participate. We just heard that in Abraham Bolden's memoir, where he was upset when he was incarcerated. He had a black doctor who didn't believe that he was also a COINTELPRO victim. And he said, this old no-count doctor, he said he was light-skinned, had a soft voice, and soft hands. And then we heard that again this week from Assata talking about her doctor to deliver her child, Dr. Garrett. And I said this back then. I did not take it as an insult when Abraham Bolden said this about the black doctor who was, I guess, looking over him when he was in greater confinement. It was kind of that, no count no good, almost sellout black dude, soft hands, and soft voice, and that type of thing. And I said then, and then hearing it today, I reaffirm, boy, I really know I have made it and become somebody. That gusty, light skin, got that soft voice, soft hands. I've heard people say nice things about my voice before, but they don't say soft voice, soft hands, that you are somebody. And easy on the eyes. See, they put all that together and say, whoa, he got that light skin and soft voice, soft hands, easy on the eyes. Woo! Anyway, 720-716-7300, the code 564943 pound. Press star 61 if you would like to participate. I wonder if you are a male. You have to be born with soft hands, or you take good care of your skin. Get that lotion and wear gloves if you're going to do some yard work, or, be lumber, loading trash at work. You make sure you wear gloves, protect your hands, get them nice soft hands. Let's see. Folks who dialed in, they have commentary to share. Even more indictments second time around. If we missed you totally, do not wait till the last minute if you have commentary. Hopefully the book club not disrupting Halloween and the trick-or-treating for folks listening in. Let's see. We got, since they were doing the same thing, they said Assata, they said she was the queen for all of the international niggras. You get in trouble with the white man, and she said, you go to Assata, and she'll say, oh, come here, Leroy. Get your passport. You are now going to be Jamal. We will send you to Algiers. Oh, man, we heard that before. We just go and Jim Jones, lots of folks. So Shamika Harris back with us. If you have commentary, we'll look for other folks, star 61.
Yes, I'm here. Can I be heard?
Yes, ma'am.
Okay. So right at the beginning of chapter 12, they put another charge on it. They said the Queen's assistant district attorney had announced an indictment against Assata, Andrew Jackson, Avon White, and 2 other Army members still at large for the attempted murder of 2 policemen, Ray Polina and Michael O'Reilly, by shooting at them with submachine guns, sawed-off shotguns, and semi-automatic pistols on January 28, 1973. This Euro charge just translated into an indictment, but was another example of the conspiratorial efforts of law enforcement agents to extract indictments against Assata and to publicize them at crucial moments in our many legal battles. So, again, with that, I was glad that she went and saw Assata. This was, I don't know, October 1973, maybe? She said, as always, we needed no protracted explanations or excuses. Slimmer and paler than when I had last seen her, she simply said, Auntie, I'm sorry, will you please be my lawyer? And I said, of course I will. So I'm glad, they're not still having conflict with one another. They go back to court. That Judge Bachman, last session, they made it sound like he was a very reasonable white man. When they would point out something that was being done incorrectly, it seemed like he would just correct it right then. But he doesn't seem like that anymore. It said, Bachman was no longer impartial, no longer reasonable, no longer willing to apply U.S. Supreme Court decisions to the particularities of this case. Responding to citizens' anger over the increased cost of the trial to taxpayers because of the expensive security measures that the county felt it had to install to delays In the previous trial, to people's resentment over the bank robbery acquittal, to the cry for the conviction of these obviously guilty animals who did not deserve the civilized privilege of a trial, maybe they should have been lynched, and to the public's need for quick and merciless justice. I had that in quotes. Bachman reversed many positions he had previously taken. I thought when it said the public's need for quick and merciless justice, I thought public was just code for white people. It said both Sundiata and Assata were Muslims. In the earlier part of the trial, no sessions had been held on Fridays, their day of worship, but Bachman rescinded this restriction, and the trial continued 6 days a week in the rush to completion. And I was thinking if it was held 6 days a week, probably the off day would have been Sunday, like in the Bible, the white, I don't know, the fake Christian Sabbath. Irony, I guess. It was just a lot of talk about how much the judge had changed. And I just thought to myself, when you're not interacting, when a white person does not interact with non-white people the way other racists expect them to interact with non-white people, they get in trouble for that. She's pointed that out a lot of times. Assata gets pregnant. They detailed the conditions of the penitentiary. Plaintiff is kept in 24-hour solitary confinement, no opportunity for fresh air, recreation, physical exercise, movies, TV, social contacts, and without minimum privacy and the exercise of her religious and personal needs. 24-hour surveillance under electric lights by female matrons who keep a written log of her every movement. The cell was infested with ants and centipedes. I just thought to myself, man, it would be very difficult to do that, and most people would go crazy. And then right after that, it said during the hearings on the complaint, Dr. Michael Oliver Smith testified about the effects of sensory deprivation resulting from the lack of natural light, lack of fresh air, lack of exercise, and basically said, a great number of scientific studies completed in the past decade clearly have demonstrated that prolonged sensory deprivation regularly causes psychotic or schizophrenic breakdown. And he concluded that if Assata had not been such a strong and independent-minded person, it is very likely that she would have had a psychotic breakdown well before this time. And then Amnesty International, they have a 1988 report that led to a court-ordered closing of the unit. And they talked, more of the conditions, and then they talked about a place in Germany. It was called Stamheim. But anyway, they were just talking about the objectives. And it said, this program, the high security unit, set up a hierarchy of objectives. The first of these is to reduce prisoners to the state of submission essential for their ideological conversion. That failing, the next objective is to reduce them to a state of psychological incompetence sufficient to neutralize them as efficient, self-directing antagonists. I'm going to stop trying to counter racism. And that failing, the only alternative is to destroy them, preferably by making them desperate enough to destroy themselves. The report concluded that these conditions were the same as the dead wing, the isolation units, and the white cells painted in high-gloss white and illuminated around the clock with fluorescent lights that existed in Germany's Stamheim high-security prison to accomplish the same goals. I took note of, the whole thing, the doctor, Ernie, they get to the hospital, they don't want to let him be the doctor. It's just so much mistreatment, and it's just racist. That's all I have for now. Thank you for allowing me to speak.
Racist say, now, she had behaved herself, not been the queen of Negro Revolution, she could have chose her own doctor, wouldn't have been in all this. Much obliged, Shamika Harris. *61. Other folks have commentary to share. Designed, all by design, to make a person desperate enough to destroy themselves. You remember that COINTELPRO, the one component that they will discuss, not that they ever go into comprehensive detail. Dr. King. J. Edgar Hoover gets him to write that letter, or J. Edgar Hoover writes that letter to Dr. King. You should destroy yourself, you filthy degenerate, before we expose you for the liar you are. Get them to destroy themselves. Or black people killing other black people, that counts as well. Get them to destroy themselves. And then we sit back and, well, niggers is niggers. They always into something. COINTELPRO, folks, very important to research. Let's see. I'll finish the first email, going to chapter 12 that we just heard. Joan Carey, Queens Assistant DA, indicted for attempted murder of 2 policemen. She went on to become a judge at age 38. The DA to judge pipeline for suspected racists is amazing. Yes, we've read quite a bit about that. Abraham Bolden's case as well. 2. Dhoruba bin Wahad, Black Panther Party, attempted murder of 2 policemen, hung jury, convicted on the second trial, life imprisonment, 19 years of incarceration. His conviction was overturned. COINTELPRO, the Daily News of New York, wrote a report about how the cops hunted the last of the black liberals. Wahad was born in 1944. He's still alive, co-founder of the BLA. With all the confusion regarding BLA, makes me wonder if they were innocent for most of their alleged crimes, and it was just a part of COINTELPRO psych-ops, psychological operations to foment fear, confusion, and ultimately incarceration among so-called black militants to neutralize any efforts they may have had to produce justice. Easy to do, and the same techniques were used with regards to NAACP, Black Panther Party, really any. That's why I said, like, what's a Mau Mau? Any niggra. What's a BLA member? Any niggra. And same thing we say about who's classified as white. Who we say. Who's a black identity extremist? Who we, white people, who we say is a black identity extremist. If you get to do it that way, oh man. Black Liberation Army might not even have been a real group, because sometimes race soldiers, they come in will just make up some group that's, oh, these militant extremist Negroes, they're bombing and robbing and looting and raping and then turn out they created this group, racists, recruited black people, go out and see if you can get some of your other cousins and join, and then they're going to go out and arrest them all and charge them with everything in the world. Long-time strategy for COINTELPRO. And Dr. Kenneth O'Reilly told us about this. He said, any black person, suspect, why? You're a victim of racism. We know we mistreat you, so of course. We got to keep tabs on Leroy. Leroy might get it together. He ain't going to take no more of this mistreatment one day. Lakeisha too. We might have to deal with him. Let's see. 3. Judge Bachman and Ray Brown, the camaraderie and respect had changed, no longer impartial. Citizens angry over increased cost of the trial, rushed to completion. His face reddened easily. They got to the judge at church, the country club, DA's office. He said church, the police, his police buddies, you name it. You better get on code, Judge. Absolutely. Like, oh my God. And I think we've heard this before too, where a white person, they may have been slightly less racist than some of the other white people, slightly more sympathetic than some of the other racists, slightly more objective than some of the other racists, and then all of a sudden, all of that stops. And what Neely Fuller Jr. said, hey, if you are classified as white, I think it was mentioned earlier, you cannot be ignorant about racism. You will get in trouble with other white people. Now, Judge Bachman may have gotten in trouble the first time around. What the hell is wrong with you, Bach? Get it together, man. You in here with this nigger woman killed a white cop and looted and is out here talking about all this. What is wrong with you? Okay, well, she come back and you go, okay, this is the one time we're going to talk to you, see what happens, do it again. Unless you change it. Oh, you're right. Because he's the one, Assata raised an objection. She said, objection noted. Assata, like, what are you doing? Tell that nigger woman to shut up and get the conviction. What's going on here? Bachman. White people talk to other white people when they are not doing it. You go, let a white person go and hire a whole bunch of niggers at the bank. Promote a whole bunch of niggers at the bank. See if you get talked to by white people. Let's see. 4. And now, masked with raised consciousness, was a rage at any inequities, selecting jurors determined to compensate for the years we had assumed its fairness. Fairness equals whiteness. Seeing things as they really are must have been difficult for him after so many years in his career. And I think sometimes it takes cases like this where it makes it really flagrant what this is. Like you've been taught all these years, hey, we're going to be fair. Treat everybody fairly. Because we've heard that. Lauren pointed that out. Shamika Harris. And then, wait a minute, y'all not doing the right thing? Wait a minute. When it's just so in your face, like, wow, they've been lying to me all this time. Really, I think for some people, for a case like this, it'll end up making you like, dang, I thought them Negroes were crazy. Dang, these white people make it sound like they might be on to something like, whoa. Anyway, 5. New York Police Commissioner Robert Daley book Target Blue in the jury room. Born in 1930, he may still be alive. Author of 31 books, 6 becoming films. Prince of the City. Did they make Target Blue into a movie? I would love to see that. Like, what? Let's see. 6. Streets surrounding courthouse, the Ku Klux Klan banners chanting white power and death to the BLA. This is not Alabama or Mississippi. Similar behavior has been discussed on the cows globally. UK, France, Russia. It's just white culture. There is no place to hide. Absolutely. That is wild, though. And this is so late, like, relatively speaking. This is like almost 20 years after the lynching of Emmett Till. This is like 5 years after the assassination of Dr. King. Almost a decade after the assassination of Malcolm X. And the Klan is marching, talking about death to us. An organization that might just be fictitious and made up anyway. Like, wow. Let's see. 7. Dr. E. Wyman Garrett, obstetrician and gynecologist. Assata, she was pregnant with Kamal's child, passed away at the age of 84. Wow. In 2018, he was a star basketball player at Morgan State University. After a brief stint in the Army, he turned down a contract with the Harlem Globetrotters. I'm clapping for Abe Saperstein, race soldier who owned the Globetrotters. Maybe Dr. Garrett would not have become a physician to help out Assata if he had been with old Abe Saperstein. Remember, he asked Bill Russell, hey, will you play with the Globetrotters? We get all the white pornography you want. sweet Georgia Brown, all that nonsense. Instead, he went to medical school, graduating from Howard in 1961. Inducted in the Newark Hall of Fame, he lost his license to practice medicine in 1987. The state charged him with 40 counts of malpractice and negligence. He allegedly killed 2 women, 14 and 30 years old, after committing illegal late-term abortions. The 14-year-old apparently died of an infection after the abortion while at home and was found by her mother. Wow. 8. National Conference of Black Lawyers and Prisoners' Rights organized Defense PROD, protesting prison conditions, solitary confinement, no fresh air, it's infested, nutritionally deficient, lack of light, damp, vermin. The NCBL, founded in 1968, they also defended Angela Davis, Geronimo Pratt, Mumia Abu-Jamal, also read about in the book club, Ben Chavis, the Wilmington 10, in addition to Assata Shakur. I think everybody mentioned there is black except for one member of the Wilmington 10 is white. They continue to exist and have a website. I am not sure if PROD still exists. 9. The conditions of incarceration suffered by Sundiata after his conviction by Sekou Odinga Geronimo Pratt. See C.O.W.S. Book Club selection, Last Man Standing, The Triumph and Tragedy of Geronimo Pratt by Jack Olson. Johnny Cochran, big participant in that book, or major character in that book as well. 10. Drove the newest model custom Lincoln Continental sedan, charged no fee, made the long trip to Rikers Island, only to be told by the doctor who was scheduled to be there with him was unable to be there. Calm demeanor to the chagrin of the hospital and prison demeanors. See the C.O.W.S. Book Club, The Warmth of Other Suns, Isabel Wilkerson, Top 10, first book, the only good book. Dr. Garrett made me think of Dr. Robert Pershing Foster, one of the characters in Miss Wilkerson's text. He was smooth. He did soft hands, maybe, soft voice, dapper, well-dressed. They still practice racism against him. He had to go all the way to California to become and practice his medicine. And even out there, the racism still. God bless the dead Dr. Foster. Assata refused any Elmhurst Hospital doctor to touch her. Supporters filled the streets in front of the hospital, permitted Dr. Garrett to deliver the baby. See Birth Behind Bars, 10 years of U.S. jail births covered in the news, highlight horrific experiences and minimal data collection. Prison Policy Initiative, Leah Wang and Bianca Schneider, July of this year. That's, in fact, Dorothy Roberts, Killing the Black Body. Talked about that one number of different ways, but certain and black self-respect. Assata Shakur, you're not going to put your grubby racist mitts on me or my unborn child. I'm going to have my doctor or do it myself. Black self-respect. And sad to say, we have not made very much progress at all. Nigh on 2030, I still hear black moms having to do almost the same type of thing, like, get away from me, I'm not going to induce labor, get away from me, I'm not doing a C-section, get away from me, shut up, you're not touching it, having to do all that, like, man, what? Anyway, we'll pick up where the rest next week. Make sure get in quickly. Well, I guess all of this about moving venue, if it would have made a difference. Let's get out of Middlesex County, because everybody here thinks Assata, Sundiata, all these folks are guilty. If you're black, you're guilty, and I don't want them as my neighbors either, any of the neighbors. And we're talking about going to Morris County, where things may or may not be better. You already know, courtesy James Lowen, Sundown Towns. I began looking immediately. Is there any evidence Morris County was a sundown town? What does the AI say? Yes, some sources indicate that Morris County, New Jersey, had a historical sundown towns, specifically Franklin Park, which was a sundown town after a violent incident in 1894. This community saw the forced expulsion of its African American residents following the event. This area has a Negro population lower than 3%, so that is a massive one. You're in the tri-state area and you have almost no Negras? How is that? Oh, and so I don't, now this might mean we have three different racial purges all in the same state, and they're all New Jersey. Like, so we got Cranberry. I told you I emailed the Rutgers folks and they said it looks like it might be 2 incidents in Cranberry, New Jersey alone. I don't think Franklin Park is Cranberry. I don't think these are the same places. I think this is something totally different. And this is 4 years before the Wilmington, North Carolina purge. Totally different. And they have books specifically about the 1894 Franklin purge. What book did you find? At least one. The Franklin Park Tragedy, A Forgotten Story of Racial Injustice in New Jersey. This was just published in 2019. Like, this is almost a Rona book. On March 1, 1894, 2 African-American privileged black dudes allegedly broke into a home in rural Franklin Park, New Jersey, and murdered and raped a white woman and her daughter. Oh, they're going to burn and kill all the niggers. Before her husband fought and killed the attackers. Another tragedy came afterward when the community conducted an expulsion of many local African American residents. It's got pictures of niggers on the front who look like they may have been expelled. I figure I got to read this just to see. Now, do they talk about sodomizing, castrating, painting white the niggers in Franklin Park too? Jesus Christ. The book again, The Franklin Park Tragedy, A Forgotten Story of Racial Injustice in New Jersey. Garden State, hang your head in shame. That right there, that's fiction. Are you serious? Are you serious? Are you serious? I'm so insulted. Anyway, because I don't think they got no fiction books about the Franklin Park purge. Anyway, so we got double sundown towns in New Jersey. I'm going to have to go back and look at sundown towns to see, does he talk about New Jersey specific? Because he might, see what he said. Let's see. Nigger is guilty. Testify against her. We already talked about that. They're mentioning like almost the exact date. I'm matching up. They were talking about some of these dates and court hearings happening on October 28th. Like, wow. Time is right and exact. Let's see. They importantly started chapter 12. She said the acquittal in the Bronx bank robbery trial did not receive the same attention the trial had. It was nevertheless widely reported. Now that right there, that's like you can make it massively popular and tell everyone in the universe Orenthal James is guilty and put up his extra dark pictures and all that, and then he's acquitted as not as enthusiastic about, oh, Juice, he didn't found not guilty. We put that on the back page. We'll get to that later. Let's see. Again, they keep having all these old trials for Assata and even Dhoruba bin Wad, where they try him the first time, hung jury, so they have to try him again. Even that, look at all the time and energy white people wasted charging black people that they know are not guilty. Johnny Cochran said that for years about, they could have said it for OJ too, but about Geronimo Pratt. White people, they had evidence that they did not disclose. They knew Geronimo Pratt did not commit these so-called tennis court murders. In fact, the Manson murders, they went to arrest Geronimo Pratt first. Any crime that happens, you did it. You did it. You did it. Black, you did it. Wasting all that time and energy, and sometimes you are allowing murderers to roam free because you want to go and practice racism and charge these niggers trying to produce justice. Like, what? Come on. Come on. And that I cannot stress enough. Time and energy. When really, O.J. Simpson could have been the same thing, where same thing meaning what? Same thing where we know this nigger didn't do this, but you know, he dated a white woman or he was uppity or whatever he did. We're gonna put it on him, and that's that. Get my final OJ in because he was acquitted October 1995. 30 years. The juice. But yeah, that just wasting all that time. And we said that some white people made careers off of this. Old Jeff Toobin, they wrote best-selling books full of lies. Or they wrote old newspaper articles full of lies and sold all kinds of newspapers for O.J. Simpson, Court TV. Or I'm a prosecutor. Now I'm a judge. You know, I big time moved up off of this. You know, got on TV, wrote a few books, got interviewed, did a documentary, you know. Let's see. I'm going to see if I can get that Daily News article, the Black Lib Army's Strategy in Blood. Like, are you serious? Are you serious? Lie all the time. Master deceivers. That's why hearing all of this, it reminded me like, oh, wow. I was really excited about going to court this year. 2 times, because Buffalo, that got rescheduled. But I was excited about going to court. I went to Buffalo before. I wanted to go to the sentencing. If the cows had been around, all this is happening, oh my God, I would have scratched and clawed to go. I guess there's so many, I couldn't have went to them all, but I would have tried to go to one of these Assata trials, like for sure. Let me see for myself all these shenanigans in the courtroom. And they even said they were trying to limit spectators. Bachman, first timer, said, oh no, we only gonna have about 20. Y'all not gonna come up here with all your Negro rowdiness. And then they relented. Now maybe the second time around, maybe he wouldn't have done that. White people got to him. That's what I mean, Baki. Get it together. You gonna let all these niggers in the courtroom? They don't need to see all this. Get this done. We don't need all these eyes on what's happening here. That's why I wanted to go. I would have tried to be at one, and even the value of that, where you can have black people, black journalists, where they can be present and give all the details. What did you see? Talk to interview some of the folks there and all of that, as opposed to all of this racist press where they just lie. I'm sure they didn't have cameras in the courtroom, so it's not like you could have just tuned in and watched everything on TV. That didn't happen until way later. But, you know, I think Ted Bundy, if memory serves. Anyway, let's see. Anything else quick before we wrap it up? Everybody can go get their candy in and all the rest of the goofy horror day foolishness. Let's see. I love it. The KKK was not chanting white privilege. They were chanting white power. I gotta see this Robert Daly Target Blue. I'm gonna see if I can find that and read the sections about the niggers. Did they make that into a movie? Did they do a film adaptation? Like, what the world? I mean, come on. I love one of my favorite portions of the book when Assata gets pregnant. Miss Williams says neither her mother nor I condemned Assata, and we quickly agreed to share the child's upbringing should she be convicted. We had long since adjusted to the fact that Assata was a product of the 60s, whatever that means, acting independently of the sexual restrictions that had so governed our lives and substituting a new morality. Now, I do kind of have to look at that like, what? I mean, Strom Thurmond is out raping black children years before this, as were many infinity generations of race soldiers. So what? I don't even know how you have such a word as morality within a system of white supremacy racism. We're on a plantation. What do you mean? Anyway, but putting all that aside, I guess I'll play along maybe for 30 seconds about there's being some sort of sexual prudishness. Whatever. But I do appreciate we're not going to judge her around this, and even the understanding the gravity of her situation and not having human contact and just all that. I don't even know what the judgment would be. Other than this is not the healthiest environment to have a child, but yes, it's not the healthiest environment for you. So yeah, and I don't know what that would accomplish anyway, to wag your finger. Now you just another finger wagging at her about a no-count nigger woman she is. So that's not helping. Let's see. They said it just stuck out to me. I guess the dominance of television, even that we've heard in the book club throughout the years, Essie Mae Washington Williams and many other books have talked about television and the power of television and going to the movies or being restricted from being able to get good seats. You got to go sit in the balcony, but at least you can go to the movies. This is one of the first times that I can recall a black person where they are totally restricted from TV and movies, and this is brought up as a violation of human dignity. I'm not laughing. I'm just saying, like, we have heard television talked about a lot, and I really cannot think of another time, like, right off, where a black person did not have access to television. Essie Mae didn't say they didn't have television, and she was talking like 30 years prior to this, like 40s and 30s. She didn't say they didn't have television. She just said white people didn't let them sit in the lower level. They had to sit up in the balcony. We heard that in Warmth of Other Suns as well, and we've heard this over and over and over all around the world. It's not that black people didn't have access to TV or radio. We just didn't get the best view. This is like the only one that I've heard like actually restricted from movies and TV, and even prisoners. I was thinking like Green Mile and movies that we love and talk about, Shawshank Redemption. They still have television. They wouldn't even let Assata get television. Shawshank Redemption is set like 30, 40 years. That's like 1940s. Before all of this is going down in the mid-70s, they still got TV. Heck, even the Green Mile, that's in Alabama, and that's set in like the 1930s. Scottsboro Boys, they still got movies. That's like, wow, cruel and unusual punishment. Isn't that what they call it? Like, now, cause you ain't gonna let them get no Netflix? Like, oh my God, just kill them. Just go ahead and put them in the electric chair, strap them in. I mean, really, like, you can't get no YouTube? Are you serious? I'm done. Just go unplug the chair. Wait, should not be wet. Let's go and get it over with. You ain't gonna deny me Chris Rock. You gonna deny me Chris Rock? Will Smith? Mama, it's been good. Go on, let's get it. Woo! And this is before we were addicted to screens. I guess we'll wrap it. Is that? Let's see. Yeah, we'll wrap. Matulu Shakur, name correct. AI does not do Latin or niggra names very well. Matulu Shakur. And I love the codification of Dr. Garrett. He didn't even get upset when they wouldn't let him in the hospital, and I guess he'd encountered so much of that. And that's another one I can end on. You could bring Dr. Garrett forward to 20251. It would be, what the hell? A doctor with a penis? A black doctor? Where did you? Where did you? Security. Let me see your credentials. What are you doing here? Where did you come from? You know they don't have no Negro male doctors. Talked about that with Dr. Uche Blackenstock right down the road a couple days ago. That's one, and then it would be the exact same thing. Get on out of here, Ernie, or whatever your name is. Beat it. Get on out of here. Ain't gonna call you by your. Get on out of here, Ernie. Negro doctor gonna take care of some black Antifa. Get on out. It would be the exact same thing. Progress. Matter of fact, that audio segment I loved playing on the cows. It was from North Carolina. Dr. McDuffie, privileged black male. He told NPR, they did it should have been Racism Project. They called it Race Project. And it was picked 6 words. His words were 55 miles per hour. I think he did MPH, one word. 55 miles per hour means you, boy. He's a doctor, and in fact, he did this interview with NPR talking about the racism he experienced as a black doctor. Like Dr. Garrett, he was fired just for doing the white people in North Carolina. Because I called him, I was going to see if he was going to be a guest on the cows. He said, I don't know, Brother Gus. You know, these white people trying to fire me. They listen to NPR. And what's the name of your show? Context the White. Oh, God. You can hear this on NPR. It's called, you could just look. It'll pop up. 55 miles per hour, MPH, means you, boy. That was his quote. And he did. And I think they brought him back. He did a couple. It was lengthy, where he talked about all the different ways that he is humiliated and abused. And white people say, oh, you get dumb white people who come in, but they're racist. And they say, hey, nigger boy, what word did you just say? What did you say? You don't use big words around. Who do you think you... Anyway, I'm sorry. Rest in peace. Dr. Garrett, I think they said he just passed not too long ago. Man, privileged black male physicians. Woo! They gonna really punish you because you're not even supposed to exist. That's why Bill Cosby... Niggra. That's Bill Cosby. I'm done. We're done totally now. Woo! I had candy corn or something. I did not. I promise you, I've not had any candy at all today. In fact, I'm not even sure I had any sugar today. I had coffee black. I don't think I even had sugar today. I had raisins. No sugar added. I don't think I had any sugar today. Anyway, I will hush my mouth and see if I can keep that up. So by the time I get back here, compensatory calling tomorrow, still maybe, will he still be able to say, no sugar? We'll see. Don't go crazy with those Snickers, because I used to do that. Oh, I would have eaten about 15 pounds of Snicker bars by myself and looked at you real nasty. Hey, Brother Gus, let me get one of them. Hey, I'm sharing my Snickers. You're already 500 pounds, though. You don't want the diabetes. I don't share my Snickers. She said lack of proper nutrition. That was me. You going to eat Snickers all day? Yep. You rot your teeth out and be malnourished. Hey. Don't do that. Don't let your children do that either. Jesus Christ. Don't let your children do that, man. Shouldn't be no holidays, man. We got shut down and counter racism. Important things, not gorging on candy. Sobriety would be best until Monday. They are fixing to act a fool all weekend long. Do not participate. Creator, remind us, not all... Stop saying not all white people are racist. So important to say that one correctly. Woo. Remind us, sobriety would be best. Cal signing out. Thanks all for tuning in.
Nigga, you so brainwashed.
I'm a victim, brother.
Problem. You're a victim.
I'm a victim of 400 years of conditioning.
Shut up.
The man has programmed my condition. Even my conditioning has been conditioned.